to mention item number 21, my lord.
21.
Yes, I have taken the concern of the other side, my lord.
Ah,
It's an old matter otherwise, my lord, but I could have contacted the client, my lord. And
lost contact with the client.
yes, my lord. And
But you have the file.
we have the file, my lord. I've been informed that my lord, he has expired in the meantime. So, in fact, I have wrote to the client also, but no response from their side.
How much time?
At least 2 weeks, my lord, I'll make one more effort to contact him.
Mr. N.J. Khatonier, learned counsel appearing for the petitioner, has submitted that he would require further instructions on the matter since the client has not been in touch with him. Place this matter again. July, did you pick a date in July?
Yes, my lord.
Choose a date.
July 14 or 15, my lord.
15th of July, 2026.
Obliged.
May I please, Lordship?
Yes.
My lord, item number 3. Already, already you took time. Mr. Ekip, because I went there yesterday. He on leave also. He is seriously ill. So
Who? Item number 3.
3. Today is also fixed. Last day, Monday also I fixed this item. So my lord, maybe on next 28th of.
At the request of the learned counsel appearing for the petitioner, list this matter again on the 28th of May.
In the meantime, if they file this affidavit.
2026, full stop. You are appearing in the matter.
No. Government.
Government, you have not filed your affidavit?
No.
Maybe we be required to file.
Actually, government, yes.
In the event the affidavits in response by the concerned respondents are not found on record on the next date fixed, this court may consider imposition of costs. You find out who has to file the affidavit. Your confusion cannot be the cause for this court to keep hanging to a matter.
I also furnished the copy.
If you have some, Mr. Pukon, if you think that you are not supposed to file an affidavit, you don't need to respond, just give it in writing that we don't need to respond. Your thinking or their thinking is not going to work. On the last occasion, you give us a piece of paper, we do not want to, we have nothing to say in the matter. Yesterday or day before yesterday, someone gave us a. We found that yes, they need to answer. Because the petitioners were original employees of that board. So they have to answer. They may not be now. Unless, if we don't find anything on record, we'll consider costs. Yes.
May I please, Lordship?
Much of.
We have given till 28th of June.
28th,
You want
yeah.
some more? Or 28th of May, when?
Yes, 20th of May.
When do you want it?
3 weeks time.
Tell us a date, sir. Madam, tell us a date.
Before vacation, let's say.
No, it will be too late.
Huh?
But,
If necessary, I'll furnish the copy. They'll get the Xerox copy because I furnished one copy also to the madam.
Yes,
Last-
just
1 year
wait.
back.
First. Have it on the 9th of June.
Well,
We'll give them 2 weeks time.
Yes.
Because on the next date we are imposing costs. So let them have some
my lordship, sir, the lordship.
9th of June. Huh? 9th of
Yeah, my lord, I just to get the from my Mr. Pukasto, then take maybe. Because he may be in the Nitanagar sometimes. That is
We'll see if they do. It is for their affidavit, not for your arguing the matter, is it?
on
We
9th
are
of June.
fixing 9th
9th
for
of,
their affidavit.
let them to file early, then we file it before. Because it is a
Yes.
case of 23.
May I please, Lordship?
Much of
My lord, one review petition was listed yesterday as item number 56.
Huh.
The petitioner is supposed to file affidavit on service, Lordship. Already I am appearing for respondent number 7.
Yes.
The
We
matter,
remember.
yes, Lord, matter is fixed, was fixed on coming 26, Lordship. It's on Tuesday. But in the CIS sheet, it is shown as 26 June. Therefore, I am appearing for listing the matter on 26/5, Lordship. As the for this honorable court order.
Mention did you? 26 paper can I mention did you? Order sheet on 20, it's in the order sheet, it is already 26.5.
But
You go and tell the registry that it is 26.5. The CIS may be wrong. If they have a doubt, our court master will clear it. In our register, it is 26.5. Don't worry.
Okay. Obliged.
You go and tell the registry, it should be 26.5.
Okay.
They have a doubt, let them talk to the court master. He'll clarify. Yes.
Obliged.
Item 7, 8, 9, and 10, 11,
Ah.
Lordship.
Huh.
Adjourned for 2 weeks, Lordship.
Why? 2019
My
matter, why?
senior is not prepared today,
Why? You are not prepared today.
Lordship.
At the request of the learned counsel for the petitioner, list this matter again on
After 2 weeks.
after 2 weeks. So, after 2 weeks, ki date dibo pare? 12th of June, full stop. The one of the matters relate to the year 2019, full stop. The petitioner assures that no further adjournments will be sought for on the next date of listing.
Right.
Matter to clear sir to matter. No, he said nahi follow them. Top of the list kuntu. Thirty-one to material. Oh no, 32 to matter. Really hetu agot আছে.
Yesterday's matter, Lordship, my dues has not been paid.
A little hustle bustle on that side. Definitely.
I plead, Lordship. Instruction received, Lordship,
What?
from the government side, Lordship.
What?
The correspondent 3, Lordship.
Hmm.
This is under process, Lordship. Also receive instruction from the board also, Lordship.
Which again?
Board has sent a proposal, Lordship.
On 13.5, on 13.5.
Lordship. And the department also, Lordship, is under process, Lordship.
How much more time? Give us
3
a date.
weeks, 3 weeks, Lordship. It is under process, Lordship.
Leave encashment has to be released. Leave
Stated
salary encashment you have sent.
Lordship, it is stated that it's under process, Lordship.
Okay.
Kindly 2 weeks time, Lordship.
What
2 weeks, Lordship.
process?
2 weeks, Lordship.
You are not taking the court's order seriously.
No, Lordship. Will obtain the instruction, Lordship.
On 2 occasions, 7/3/2023.
I have obtained the instruction, Lordship, in time, Lordship. Lordship, department is,
In 4/4 or so, Lordship, they have undertake before this whole court.
Your prayer is for release of now. What remains to be released?
only, Lordship, prayer is only, Lordship. To
release
release,
of what?
to release the leave salary encashment, Lordship, and other,
That is your.
and other such benefit.
What are the other benefits?
Other benefits means, Lordship, they have stated that other benefits, and they have stated, they have, however, except leave salary encashment and other retirement benefits have been paid to the petitioner by the respondent authorities, Lordship. They have stated, Lordship, in
Has been paid?
para 5, Lordship, in his
Para-
writ petition, Lordship, para 5, Lordship.
Except
Lordship.
leave salary encashment and other retirement benefits. Yes, sir. Can you identify what
Lordship,
other benefits?
My entitlement with respect to only leave encashment.
लिखिए heard Mr. S.C.K. Learned Senior Counsel assisted by Mr.
KJ.
K. Jain. Learned Counsel, 'appearing for the petitioners. Also heard the Learned Counsel Mr. Chakraborty,
Lordship.
appearing for
Respondent number 3, Lordship.
respondent number
3.
Who is respondent number 3?
3, I am appearing, Lordship.
Who is 3?
And also, Representative Commissioner and Secretary, Urban Development Department, Lordship.
Full stop. Your name? Your name, madam? T. Das. Miss T. Das appears for the respondent number 1 and 2. The petitioner in this case had retired on. Help us a little.
On return on 31/1/19, Lordship.
2019.
31/1/2019. And it is the case of the petitioner that his leave salary encashment had not been paid to the petitioner by the respondent authorities despite several representations. The petitioner approached this court in the year 2021. And since then, the aforesaid leave encashment entitled, although admitted, has not been paid to the petitioner. This court on 25/2026 had recorded the intent of this court recorded the observations of this court regarding the delay being caused at the caused in the office of the respondents. Full stop. An attempt to mediation had also failed. Full stop. On 25/2026, the Mr. Chakraborty, learned counsel, appearing for the respondent number 3, sought for an accommodation till today to have an updated instruction. He has produced an instruction dated 20 May 2026, whereby he has been informed that the matter regarding this present writ petition is under process in the Department of Housing and Urban Affairs. Another instruction issued by the respondent number 1 and 2 reflect that the proposal for release of the leave salary encashment to the petitioner had been forwarded by the respondent number 1 to the respondent office of the respondent number 3 on 13/5/2026. Full stop. The learned counsel for the petition for the respondent number 3 has prayed for an accommodation of 2 weeks for processing the case of the petition, for processing the payment of the leave salary, processing the approval and or payment of the leave salary encashment to the petitioner of the petitioner by the office of the respondent number 3. List this matter again on. Choose.
On 18, Lordship. 18th of June. Lordship.
Both 11.
18, Lordship.
18 দিব পাৰি of June. আছে নেকি matter লাগি? On the 18th of June 2026, full stop. This order shall not be interpreted by the respondents to have diluted the other orders which have taken the action of the inaction of the respondents in processing the case of the petitioner seriously. Full stop. It is only on the assurance of the respondent number 3 through Mr. A. Chakraborty, learned counsel, appearing that this court is not imposing the costs at this stage or is not passing orders on payment of interest on the amount due to the petitioner, full stop. In the event the respondents fail to keep their assurance, this court would be constrained to take up the issue of imposing costs and for interest on the delayed payment of admitted entitlement of the petitioner. Please again on.
As per communication, Lordship, I have stated.
That is why
Lordship.
he has assured through you.
Lordship.
We are not trapping you.
Obliged.
Yes.
Much of it.
Yes, sir.
My lord, in this case, on earlier occasion, the hearing ended and we filed a written argument. Is the written argument is available in the file?
We heard the matter.
No,
No, on
that was 2 years back.
before that. Yes.
Written argument is there. Is it in the file?
Yes, yes. We have got a memo of written submission on behalf of respondent number 3457. There is an extra copy. Is this the one you have given, Mr. Abedin? This is the one you have given?
Written argument submitted on behalf of the petitioner.
বৰুৱা এইখন দিয়কচোন, এইখনৰ কথা কৈ আছে নেকি সুধকচোন। Oh, yes, yes. We have got another one here.
No, it's not this.
We have got another one. Yes.
Yeah.
This might have been some note prepared. Just a minute, huh? This appears to be a note. May come in handy. Yes.
My lord, there are 4 important dates to be noted down before I proceed, my lord,
Huh.
because the entire case will be revolving around those 4 dates. If your lordship pleases to note down.
Tell us.
My lord, 27/6/1993, one MS Punia Gogoi was appointed. Joined.
K.
No, Punia, PU. MS P Gogoi.
Punya Gogoi or Punya?
Punia, PUNIYA. Punya.
Punya Gogoi. It should be Punya Gogoi. Ha, P Gogoi.
P Gogoi joined.
Huh.
31/12/1996.
31/12/1996. Huh.
Petitioner joined. 6/6/2006. My lord, R6 joined. 8/11/2008. R7 joined.
Punya is not a party in this petition.
No. Your lordship can mark it. She is already provincialized.
Okay.
She was provincialized with effect from 1/1/2013. That is under the 2011 Act.
Huh. Okay.
Okay. My lord, would your lordship be pleased to take my writ petition, my lord?
Yes.
I directly come to the Annexure 3, that is page 31.
Hmm.
My lord, that is the appointment letter of the petitioner. That is 15/12/1996. I joined, my lord, next annexure 4, 32, that is 31/12/1996. Now, the aspects regarding the rounding of 54.5 plus to 55, it comes, my lord.
Hmm.
Annexure 5,
Rounding off allowed.
yes, my lord, rounding off as 55 is allowed.
Ah,
That is dated 6/9/89.
September.
Okay. Now, next is Annexure 6. That is page 35, where regarding the rounding of the last part, my lord, of that annexure, I'm directed to say that 54 points so and so obtained by a candidate so and so file should be rounded off to 55.
Huh.
That is by the joint director. Now, this UGC notification, Annexure 7, which I have given over here,
1998.
1998. So I'm not covered by that, my lord. My appointment is 96.
Okay.
Okay. My lord, over here, if your lordship looks at the page,
Anything prior to 1998?
no, that is regarding that 1998, the state adopted the same wide OM dated 13/1/2000, and the Director Higher Education notified the same by notification dated 25/2/2003. So prior to that, it is not in dispute also.
No, what I was trying to understand is shall remain. If you see page 41, it says shall remain. Perhaps there was something prior to this by the UGC which had kept it at 55. Page 41, 3.0. Minimum requirement for good academic record so and so or an accredited test shall remain. Shall remain means it existed and it was kept.
Yes, yes. No, what the notification 98 was regarding net and slat. After 98, the UGC made the net slat mandatory. Our state adopted that in the year 2000. So prior to that, only the MA degree was necessary with 55%.
Where is it? The UGC had said it somewhere that it will be only 55% in MA. Prior to this, there was some notification. Okay, leave it. Then
In any case, that is not in
Leave it.
dispute also, my lord. My lord, then your lordship be pleased to see the Annexure 8.
we go back. Annexure A of what?
Annexure 8, page 45.
8. Huh.
My lord, this is as abundant question because of that my 54.5. I ultimately cleared through distant mode, I cleared the MA with 55.8. Now the crux starts, my lord. 2013, Annexure 10. My lord got it. Annexure 10.
Yes, read
My lord got it.
it. Huh?
So there is a
They
there is a
uphold
check.
till they have upheld it till 222023.
Okay.
Anybody appointed prior to that will be okay.
So I'm covered.
Hmm.
Now, my lord, as your lordship is aware, the 2011 Act came for provincialization.
Hmm.
My lord, over here the story begins. When the particulars of the economics faculty was sent for consideration of provincialization,
Hmm.
the college authority sent the name of that Punya Gogoi
Hmm.
alone.
Hmm.
Whereas at that point of time under 2011, I was there to be considered, but my name was not sent. The reason not sent is that what my lord has just noted down regarding the 4 persons. Respond number 6 and 7. Respond number 6 was 2006 and respond number 7 was 2008.
Hmm. What
In
are
your
their
lordship
names?
note,
Respondent numbers 6 and 7, what are their names?
the names I'll give it, my lord.
Where do we find it at page 50? Just tell us that.
Seven's name is Mosumi Gogoi.
The in
Seven is
50,
mostly-
your lordship will not got it.
Page 15, they are not there.
No, page 50, they are not there
Okay.
because they are not qualified
Mhm.
at that point of time. Under 7(1) of that act, they had to have the 7 years continuous service. So they did not have the 7 years continuous
Okay.
service. As such, they were not there. Only name of Punya Gogoi was sent.
Hmm.
And my lord, one thing, respond number 6 is Mridusmita Gogoi.
Hmm.
And 7 is Mosumi Gogoi.
They were not there. Good.
They were not there because what I'm saying, my lord, their name not there, they could not have been sent because they did not have the qualification mark to be considered under 2011 Act.
Hmm.
So as these 2 persons were there
Hmm.
in 2006 and 2008 appointees, and I was the second senior most in the faculty,
Hmm.
my name was not sent. And interestingly, I was not aware. When only Punya Gogoi's name came to be provincialized with effect from 1/1/2013, when I asked my principal, then he said, no, your case will be considered in the second phase. As your lordship is aware one thing, when the 2011 Act was first provincialization took place, then there was the steps were taken that left out or some unconsidered will be taken in the next phase. But in the meantime, because of the Chandan Gogoi's case, when it was declared ultra virus, everything was closed.
Hmm.
And 2017 Act came in.
Chandan Neog.
Yes, Chandan knew. I hope it was there. Chandan Nagar. My lord, Annexure 13,
Hmm.
Annexure 12, I think your lordship should mark it, my lord. Serial number 13 is there. Page
Annexure?
50, page 50.
Punya Goshi is there, huh? That's
Yeah.
good.
That can be marked, my lord. No issue. Now, Annexure 12, my lord.
Their names are sent.
Their names are sent.
Hmm.
And interestingly, my lord, their date of joining is given as 6/6/2006 and 8/11/2008.
Hmm.
That is serial number
5 and 6.
5 and 6.
Huh.
But my name is not sent still.
Okay.
Now, annexure 13,
Your representation.
my representation. And over there I say that I have the required qualification and I'm fully eligible for the same post, yet I have deprived from the second post of assistant professor by overtaking junior one. My joining date is so and so, madam. How can it be possible? So I request you to do justice for me.
Several representations. There are
Yes, yes. My lord, annexure, then annexure 16 is the provincialization that took under the 2017 Act.
Hmm.
Your lordship is aware that matter in college, in particular faculty, there are three assistant professors who are considered.
Yes.
In earlier only because of Punya Gogoi, other twos are there.
But
So
they could not be considered because of they are not fulfilling that 7 years.
7 years. Now
Now they are considered
considered
at
annexure
page 57.
57. Yes, well, that serial number 199 and 201. Musumi Gogoi and Midusmita Gogoi.
199 and 201, huh?
Yes, my lord got it.
Yes.
My lord, then my representation, annexure 17. Now, my lord, your lordship may come to page 60, my lord. My lord got it. List of incumbents not considered for provincialization of services in respect of 134 numbers of provincialized colleges for provincialization due to non-fulfillment of required criteria as per provision of the Assam Educational Provincialization of Teachers and Reorganization of the Educational Institution Act 2017 and amended 2018. My lord, this list is for the 4th faculty member. Now my name appears, my lord, page 61 against 273.
Number of students is less.
So, my lord, over here, one thing, your lordship, for my case, for my petitioner, there is a crux over there. It is not that I have been not considered for my qualification. It was not considered because there was less appearance. And less appearance, I'll come to the act, my lord. 150 is required in the last semester. That is the 6th semester of graduation, my lord. That is-
If the people have studied but not appeared, how can you help it?
Yes. No. 150 in the last semester is a difficult job. That is the reason in all over Assam, other than the major subjects, there is not the 4th faculty normal members, my lord. Well, at that point of time and one point of time, I did scrutiny that, and I found only in respect of Assamese subject in Cotton College was the 4th given throughout the state of Assam. Because no colleges had the last examination, that is the last 6th semester appearance as 150, particular subject, were considered to be a 4th faculty member.
Okay.
Now, my lord, at that juncture, I filed this writ petition. Taking I made one of the allegation of malafide. Why? Respondent number 7 and respondent number 6 My lord, respond number 6, honestly, if I become the second faculty member, she becomes the third. And if I don't become, then she becomes the second. Anyway, she is safe. The problem occurs with the respond number 7. What I say in my writ petition, it's just to accommodate the respondent number 7 in the guise of 6 and 7. My name was not sent by this college authority under 2011 nor under 2017.
No, under 17 it was sent.
No,
Then how was it rejected?
that was rejected after the provincialization and everything was over. Then, your lordship, there was a steps for sending the names of the persons who were left out. And my case was then sent by the college authority
It is
as
not under the 17 Act.
under the 17th. After normal provincialization was over, then there was another steps that if any leftover,
So, for 2000, under the 2011 Act, your name was not sent at all?
2017 also not sent at all.
Acha.
It was sent after the 2017 normal provincialization was over. And my case was sent as the 4th lecturer, which demanded that 150 students must be there in the last semester. Knowing that, the college authority knowing that we don't have the 150, make him happy. Make her happy with that forwarding note, and that's enough. Now, why I say, my lord, everything was done because of, for benefit of the respondent number 7. Respondent number 7 owned his sister-in-law of the principal. Respondent number 5 was the vice principal, that is the wife of the respondent number 4, that is the principal. And president is the mother-in-law of the respondent number 5. Only the case. Now, interestingly, my lord, one aspect your lordship would consider, last annexure. My writ petition last annexure.
Yes, we've seen that.
See the date, my lord. Date.
9/9/21.
Yes. Provincialization was done in the month of May. And this letter is issued here in the month of September. And see the, I would like to read the, my lord, content of the letter. After 25 years of my service, this letter was issued to me. After the provincialization of the respondent number 6 and 7, I would stress that only to benefit the respondent number 7. The letter reads like this, my lord. This is with reference to your letter dated so and so regarding the clarification of your queries. I would like to inform you that your letter has been placed in the governing board meeting held on 28/8/2021. After threadbare discussion, the GB considered your claim totally unjustified as you are a below norms candidate till 2011. My lord, your lordship can mark that till 2011. And Mrs. So-and-so placed at second position with her UGC norms 55, and she was granted financial assistance since 2006. GB also noticed that college authority sent all the documents to the concerned authority as per guidelines from DHE. So your grievance that college authority had the intention to deprive you is totally irrelevant. Furthermore, although GB felt your unauthorized absence for 3 months as an irresponsible act, yet with a very sympathetic consideration, GB resolved to accept your services again in the college with your earlier position if you are interested to continue. So GB took the resolution after 25 years of my service that I'm not qualified. Now, why I said your lordship can mark that candidate till 2011. This is interesting because 2011, for one, only 2011, your lordship. First, your lordship, though it is the case demands, my lord, though the act has gone, still I would just refer one clause in 2011 Act, my lord.
What's page number?
2011, I don't know if it is the same book.
650.
It is
No, 640. No, not 647. Yes,
647 is, I think, is the same book.
same book, huh?
Yes.
Tell us.
Well, would your lordship be pleased to come to 5.1?
Hmm.
Page 655.
Hmm. 5.1, yes.
My lord, first point to be noted, my lord, only one thing, I'm sorry, my lord. 4.1, that proviso, my lord, provided.
Hmm.
My lord got it, that requirement of 7 years,
Hmm.
that is there, my lord. The reason their name was not sent, 6 and 7 could not have been sent in the year 2011 because of this clause. My lord, regarding that 5 years benefit of, that is,
5.3.
I think, 4.3, my lord. 4.3, I'm sorry,
No,
I mentioned
4.3, not
5.1.
4.3, yes. Proviso.
Yes. Number one, I had the 54.5 plus. So if it was 0.5 plus more decimal, then it went to the less integra as the round of provision at that point of time.
The respondents have issued the notification.
Yes.
Those are not under challenge.
Okay. Now, they only for that ground, they did not send my name. But what I'm saying, in 2011, when the act came, before that, I have cleared that 2010 only, I cleared that 55 also. That is, then also it's not sent in the 2017. They could have sent in 2011, taking my subsequent betterment. But then there was a provision that proviso to 4.3, provided that if an employee is required to acquire any prescribed academic or professional qualification, service of such employee may be considered for provincialization if otherwise eligible, but in such case, the provincialization would be subject to acquisition of such prescribed qualification within a period of 5 years. So there was no hurdle for the college authority to send my name over there. If the department or the state would have not considered my case, I had the other remedy to force them, yes, because of this and this, you should consider. And in my case, it was already prior to that. The proviso is that if anybody still requires, but mine is 2010, I've got this as an abundant question.
Suppose someone did not have the educational qualification. Was it required under the Act to send his name also? And after provincialization, he would have got the 5 years to acquire the requisite qualification.
Yes,
That is what the case,
Yes.
that is what the Act says.
yes.
So even if we take it that you did not have the qualification, your name could not have been held back.
Yes.
Can that be the argument?
No.
That my name would not have been held back even if I don't have the qualifications, because after provincialization, I would have 5 years to acquire the qualification.
My lord, I would see this proviso.
Whatever was required to be you
At-
to have at that point of time, if you had that, and if you do not have what is required now, in that case, your name will be sent, you will be provincialized, and given 5 years to acquire what is required now. Is that the reading of 3 and proviso?
But over here, the wordings are bit different, man.
Please read it again.
Provided that if
No,
an
you
employee,
read from the top. 3.
the service of a teaching or non-teaching employee in a venture educational institution
Up to higher
up
secondary.
to higher secondary level
You
shall
say
be
you teach at what level?
degrees there.
No, you teach at degree level.
Degree.
Now, next, in case of employees of a degree college,
Hmm.
they must have acquired such requisite educational as well as professional qualification as may be determined by the University Grants Commission from time to time.
Yes.
That is why I had asked 1999 when you were appointed, no,
96.
1993 when you were appointed. The norms were 55%. State of Assam interpreted that norms to say 54.5% will be read as 55%. You have the norm, you are required to be appointed. So the state government's stand now cannot change. Their stand has to remain that at the time of appointment,
Till
you
2003.
had the educational and professional qualification, whatever was required to be appointed to that particular post. Thereafter, from time to time, whatever changes come, you had to comply with it. 2011, you complied with it. You got 55%. Even if 54.5 was not enough, you got 55. Thereafter, provided that if an employee is required to acquire any prescribed qualification, he may be considered for provincialization if otherwise eligible. Meaning, if you are required to have a qualification but did not have it, but you fulfill all the other norms, in that case, you will be considered for provincialization, granted it, but for a period of 5 years.
Yes.
5 years you don't get it,
Then you remain as a tutor.
there was no concept of a tutor here, sir.
No, not here. In the
So there
2017.
will be no tutor part.
Yes.
Take within a period, and during this interim, he may continue to work on the existing terms in which he was working until his services are provincialized.
Yes.
And if you don't get it, so what they are saying is, you qualify all the other norms, you miss out on one norm, your name will be considered. You will not be provincialized. You will continue to work as if you are not provincialized. You will continue in the college. Acquire that within 5 years. get your provincialization order. You don't acquire it in 5 years, you are terminated.
Yes.
That is what I have understood. Is that how we read this or some other interpretation?
No, if that way also read it is okay. Because for that 5 years, I get the benefit of that 5 years or the chance of that 5 years.
You remain under consideration.
Yes,
You
I
have
remain-
given the benefit.
Yes. Now, my lord, directly your lordship may come to page page 116 of this book, my lord.
Hmm.
That is
Yes.
under 2017 Act,
Hmm.
section 7.
Hmm.
My lord got it.
Yes. But under 17 Act, you were not given the provincialization because of the number of students.
No, two things over there.
Hmm.
What I have said, in 2017 Act, when the preliminary provincialization concept was taken over by all the institutions, at that point of time, my name was not sent.
But
It was
at that point of time also that 150 students requirement was there.
there.
So even if it is sent, the rejection would have been on the same ground.
But not mine. I would have been, I'm already in the second in the faculty.
Which second? In?
I am second senior most in the faculty. It would have been the fourth one.
No. Even if we do not disturb the persons who were already provincialized, in that case, sending your name in 2017 would be as the fourth person, even at the first time.
No.
If we do not disturb
No.
the other two.
No. Let me get it, let me clarify a minute. If they send in 27 in 2017, if my name was sent along with 6 and 7, then my name would have come in the top.
6 and 7 have already gone under the 11 Act,
No,
under the 17 Act.
11 Act that could not go because there was not qualified, and because of them, my post was
So
kept
they were
hanging.
sent again in 2017.
Yes. Last, what I'm saying, it was not initially. Initially, they got the provincialization. When I said, where is my name?
Then they sent it on the second round.
Second round for the fourth post, for the fourth faculty member, which required 150 students.
Okay.
And why my name was not sent in 2011?
So your claim, no, whatever happened in 2011, why your name was not sent, we could have some penalty on the persons who was required to send
No.
it.
Now, what I'm saying now is the case demands that to portray that because 6 and 7 did not qualify that 7 years.
This court in different cases have held that even if your name was not sent under the 2011 and whatever be the cause, you have no cause of action now. It's gone.
Yes.
Let us not consider it at all. We can restrict it to saying that although your name was required to be sent along with the petitioner number, along with the respondent, along with the person who was provincialized in 2011,
Yes.
it was not sent. And we can add one sentence, be that as it may. We leave it at that. That factual part. What implication that intent would have, what we can draw inference is another thing. But fact remains that it was not sent, we leave it at that. 17, these two persons were sent. Your name was not sent. Then your name was sent in the second round. By that time, you were projected as the fourth
faculty member.
So your case is that 2017, when the other two names were sent, your name should have gone together.
Yes.
And if it had gone together at that point of time, you would not be the fourth person, you would be the second person.
Yes.
That is your case.
Yes. And my lord, the entire case over here of the, now my lord, would your lordship be pleased to come to the written argument, my lord? I think we'll finish it today only. It will take another 10 minutes, I'll 5 minutes, I'll finish it.
Then you took
2 minutes.
an hour,
5
2
minutes.
hours, 3 hours, 4 hours.
No. They
Both
said
of what?
5 minutes, just said 5 minutes.
Okay. Yes, a written argument, which part?
My lord, first initial parts are there, what I have already submitted. My lord, would your lordship be pleased to take was it 5 to 11? Page 5 of my written argument, my lord. 666.
Okay.
My lord, in the third paragraph, did your lordship get in as per section 4.2 in page 5?
That's only one page, huh?
In page 5 of
Hmm.
my written argument, third, in this para 11, second paragraph, third line, 4.2, as per section 4.2.
Hmm.
Would your lordship be pleased to make it 5.1?
Okay. Done.
My lord, another, would your lordship be pleased to see 8, page 8?
Hmm.
Page 8, my lord, 1, 2, 3, 4, 5, 6. 6th line, my lord.
Hmm.
My lord, that appointed as a lecturer in economics on, my lord, that is actually a dash. Till now, it is not disclosed as to when.
Where? Where is the dash?
No, the dash should be given, my lord. Actually, I did not give the date because
On 25,520,2006 is wrong.
no, 6th line, 6th line.
On, after on, there will be a dash. Okay.
Yes, yes.
Okay. Appointed as a lecturer on dash. You have not, you do not know and they do not know.
No, not yet disclosed.
Or respondent number 7 also does not disclose in
No,
her
that's not
affidavit.
disclosed.
Ah, fantastic. Yeah.
Over there, I did not come to that point. 2008, November, she got the MA pass degree.
So she was only qualified in 2008.
2008, November.
Hmm.
And incidentally, she says she has done MPhil in 2009. So it is not possible.
In a year.
Not possible, not a year also. I don't
Few
know.
months.
Yeah, a few months. I did not raise that because I have got a different point of 54.5 plus, my lord. That is the reason. I don't know why they did not disclose. And maybe, and what I said, my lord, that is, I've taken as a strong voice, my lord,
Hmm.
that respondent number 7, because of her, every manipulation was done, and it is her own brother-in-law is the principal, her own sister is the vice principal, and incidentally, principal's mother was the chairman of the governing body
At that point of time.
at that point of time. And because of that, the stay was granted.
So it was only a provincialization for the sake of provincialization, not
No.
done by an organization. Hmm?
Yes, that is my plea.
Ah, your plea, your plea. What do you say on this? Because you've just gone through this, your written argument. You did not submit that document to the college.
Which one?
Your MA pass certificate of 1991. Stand taken by the. If you come to page 6(2).
My lord, I think I did not make much statement over there. I think possibly in my reply, I said it is not 2000, they meant, I think 2011. Subsequent.
No,
Bec-
2011, they will not mean it because
No, 2009 cannot, 91 cannot be because 96 they appointed me after selection.
no, because 2011 is the next submission at the next page 7. Number 3 is 2011.
So, my lord, that
They are trying to say that 91 you did not submit, 2011 you did not submit. When you don't give us a certificate, you may be appointed, we don't know. But when you are supposed to send it for provincialization consideration and all, we did not have your MS certificate. How could we send it?
no, but only thing is that when elaborately when their counter is read, their entire question of that 54.5, it has to be 55. They did not say on this. Secondly, interestingly, my lord, regarding 2011, the college authority says I did not submit.
Hmm.
But private respondent in their counter, they say, your seniority can be counted only from 2011 because you cleared 55 plus 2011.
So they know.
They know, but the college authority does not know.
Could be.
And your lordship is aware that I have to submit only before the.
You must also appreciate that a person as such and the post he holds may be two different things. So personally, respondent knows.
No, I believe that. What my lord is,
personally she knows.
what my lord is trying to point out, I believe that.
Personally, she knows.
Yes,
Sitting in the chair, she does not know. Could be.
Yes, yes. True,
I may
true.
know so many things.
Yes.
Sitting here, I don't know anything.
At one point of time,
Anything
my
more?
lord, at one point of time, we used to know lots of things, but before the court, we could not say anything.
Anything more on this?
No, no, my lord, only that much.
Okay.
I think only one thing your lordship may point out, I may point out before my lord. As on date, today, this petitioner is 59 years, 5 months and 14 days. Should be somewhere noted, my lord.
3 months left.
No, it is about 6 months left.
59 years,
5 months.
6 months.
Yeah, 50. Today, exactly, it is 14 days. So only 6 months left. If she gets the benefit, she will get for only 6 months. And it is almost, your lordship, it is 30 years of service. 96 appointee.
Who appears for the college?
That's all, my lord.
Let us hear you first. Who? Who are you?
And question number 7, well.
Betara.
My lord, may come to the writ petition. I will
Hmm.
not take much time, my lord. I will simply draw the attention of my lord to the documents.
Ah.
Then close, my lord. My lord, kindly come to page 29
29.
of the writ petition, my lord.
Hmm.
My lord, she has enclosed her certificate,
Hmm.
mark sheet
Hmm.
of following at a marks of Jita Hazurika so and so PG classes at MA previous examination in economics 1991
Hmm.
held in July 19
Hmm.
and at the bottom 21 September 1992. In 1991 she cleared her previous pilot. And in the next page 30 MA final examination in economics 1990 held in 1991, my lord.
Hmm.
While joining in the college, my lord, these documents were submitted by her, my lord. Kindly see, there is a difference. She has passed her final earlier, previous letter, my lord.
Hmm. Hmm.
And next, my lord, kindly see page 31.
Hmm.
She was appointed in Dibrugarh City College, Dibrugarh.
Hmm.
This college was entirely private college. It was opened in a government high school for a short period of time. Thereafter, this college was renamed as a Nandalal Borgohain City College because Nandalal Borgohain was the founder person. He has founded many educational institutions at Dibrugarh, my lord. My lord, then come, my lord, to page 33.
Hmm.
This is important, my lord.
Hmm.
The college was established in 1992 and recognition was given in 2005. And this is the letter by the Joint Secretary regarding revised UGC norms for college lecturers. This is dated 6 September 1989, my lord. I am directed to say that 54.55% marks obtained by a candidate in MA, MSc final examination should be rounded up to 55 and such candidate will be eligible for consideration for the post of college lecturer. My lord, he has shown these documents, my lord. So we have filed a written argument also. So what this is concerned, my lord, this document is a document by the Joint Secretary, my lord. This is an office order, my lord. And so far Indian Constitution is concerned, my lord, entry 66, no? Entry 66 has clearly said that so far university is concerned, the law laid down in the central list that the UGC regulation will only applicable and that the power of 55% the UGC has recommended cannot be taken away by office memorandum.
When you rejected his case, when you did not send his case
My lord,
for provincialization,
my lord.
are these notes available in your resolutions that these are the persons we would send? We will not send this person because of these reasons.
Yes, my lord.
It is there in the resolution.
That is honest.
The Constitution of India and the, what did you say? Entry what?
Entry 66.
Entry 66. Was it considered by your college at that point of time?
My lord, that is true, my lord. My lord,
That is true. Was it or was it not?
No, that was
No.
that has not been considered, my lord.
So substituting reasons now.
Yes, my lord.
Okay.
Now, my lord, may come to page 41.
Tell us that you have not appointed her to the college. Where is your statement in the affidavit?
My lord,
In your affidavit that you did not appoint her to the college.
no, she
Is there a statement that you did not appoint her?
no, she was appointed in the college.
How? She did not have 55%.
Now, at that time,
Entry 66 was not taken into consideration.
at that time, my lord, college was not provincial. It was a private
No,
college.
it was a private college. At that time when she was appointed,
My lord,
entry 66 was there,
my lord,
NCTE was there,
my lord,
which came in 1998.
my lord,
Is it?
my lord.
And you appointed her in
96, no?
1996.
6, no?
Now, when UGC says in 1998 that it should be 55,
My lord,
and a person stands appointed in prior to the notification,
my lord.
entry 66 will still come into play to null and void her appointment at that point of time? Cannot.
My lord.
Cannot.
My
Is it
lord,
not?
Yes, my lord. At that
So
time,
a person who was appointed before there is a change in the recruitment rules,
my lord,
he would lose all opportunity? Cannot.
my lord,
He continues.
my lord.
He continues well and good.
Yes, my lord.
The government says that 54.5
Yes,
is equivalent to 55.
my lord,
Yes?
my lord.
You accept it.
My
When
lord, that-
appointing,
my lord, that was-
when appointing anybody, you accept it.
My lord.
Correct?
And at that,
You had made that provincialization, you had transmitted the records
yes, my lord.
when you were still a non-provincialized institution.
My lord,
So now don't bring in that part of what has happened after, what will happen after provincialization.
my lord.
Prior to provincialization, you accepted that government norm that it will be 54.5, we can appoint people.
My lord, that the government norm, the petitioner himself has said that it was continued only up to 2003.
He was appointed prior to that.
Yes,
So till 2003, whoever is appointed
yes, my lord,
with 54.5
my lord. They could have been,
sent.
yes,
He was appointed prior to 2003
yes,
with 54.5.
yes, my lord,
He could have been sent.
yes, my lord.
Tell us why you did not send it.
My lord, at the,
Not from arguments as to whether he should have had 55 or not. Tell us the reason why you did not send it as per your resolutions taken by the governing body.
my lord,
In the final order, you say that we, the governing body, we have sat down and we have discussed. This is our decision.
my lord,
Prior to the decision, there will be a resolution.
my lord,
2011, when you did not send his name
my lord,
and you sent somebody else's name.
my lord,
2017, at the first round, when you did not send his name
my lord,
and you sent someone else's name,
my lord,
not to send his name should have been a decision. There were 3 candidates.
my lord,
One was not eligible.
my lord.
2 were eligible. According to you,
Yes, my lord.
that he is not eligible. What was the basis of that decision, sir?
My lord. My
Show
lord,
us that.
my lord is correct. Of course, record is not with me as on that. But kindly see,
If we
Kindly
stay
please
the
ensure 54,
provincialization,
50
if we stay the provincialization and the salary of the persons who have been provincialized till now,
my lord.
will the records be available
It is already
by the
stayed.
next date of the listing?
It is already stayed.
Huh.
From the
Still
first,
no records. How do you, from where are you arguing
My lord,
that you had decided
my lord,
not as a single person?
my lord.
We decide here as a single person.
My
We
lord,
write down 7 pages, 8 pages, 10 pages. Where is your decision, sir? This lady is not eligible.
my lord,
2017, prior to sending their names.
my lord, kindly see. That notification was applicable only up to 2003. This is an admitted fact, my lord.
Forget it.
And this,
This was the basis of your decision not to send her name.
my lord, because-
Show us that decision.
my lord, the 2011 Act of Provincialization.
You do not
Section-
answer our question, we will refuse to hear you.
My lord, kindly section 4.3. This answer is here, my lord.
Tell,
I am giving that.
please, please.
In case of employees of a degree college,
Hmm.
they must have acquired such requisite educational as well as professional qualification
Hmm.
as may be determined by the University Grant Commission from time to time.
Hmm.
This is in the 2011 Act provision, my lord.
Your name, sir?
S.S. Goswami.
Sir?
S.S. Goswami,
S.S. Goswami.
my lord.
If we refer to you as Mr. S.S., would you be happy?
Yes, my lord.
If we refer to you only as S.S. and not the Goswami part,
My lord.
will it be your complete name?
Not-
It will not be a
not-
complete
not
name.
be complete,
That section is incomplete with the proviso.
my lord.
Without the proviso, it is an incomplete section. Please read the section. The proviso.
My lord,
If someone does not have the qualifications as required,
my lord.
but is fulfilling all the other necessary norms,
My lord.
his provincialization will be kept in abeyance.
My lord.
He will continue under consideration.
My lord.
And within 5 years, if he can show to the government that, sir, I have completed the qualification,
My lord.
he is provincialized.
My lord.
Otherwise, he is not. That was 2011.
My lord.
That goes. 2017, what does it say? If the name is sponsored without qualification,
My lord.
what does he become? Tutor.
Yes, my lord.
Yes. Were you the authority who should have forwarded the list of your persons
My lord.
who are teaching in your school?
My lord.
Let the DLC and what SLC, what are they called? The
S-
district level committee and
DLC.
state level,
State level scrutiny committee.
SLSC,
Yes.
GLSC
No,
and
no, this district scrutiny committee, DSC.
DSC and SLSC.
Yes.
Yes, my lord.
They will see who is there and who is not there in the qualification.
My lord.
You did not sponsor the name. Who were you not to sponsor the name?
But, my lord, I have filed one affidavit requisition.
Who were you to not to sponsor a name? Tell us that.
My lord, I have filed one affidavit.
Yes, we are reading that page 92 of the read petition running page.
Huh? My lord,
We are at page 92.
92 of the writ petition.
Pure
With
this
your affidavit.
affidavit. They are now running paged, is it not?
Or running page of,
What page number are you trying to read?
running page is not main, my lord. I have
Not
sorry.
necessary. Tell us your affidavit page number.
My lord, page 58.
Page
58.
15.
Yes, last two page.
Yes.
My lord, this is a letter by the principal.
Affidavit by whom?
Affidavit by three.
Respondent number 3, 4, and 5.
Yes, my lord.
There is no page 50.
3, 4, and 5.
Your running page number?
My annexure 9.
Running affidavit or page number kiman?
58.
Just a minute. Just a minute.
It's the letter
Page
that my lord
50.
Nandalal for my city college.
Yes, tell us.
My lord, this letter is dated 31/8/2020 by the principal,
Hmm.
forwarding the particulars of the writ petitioner
Hmm.
to the director of higher education.
When was the documents of the respondent number 6 and 7 sent?
Yes.
My lord, kindly see the second page.
Tell us the date on which you sponsored the other two teachers.
In 2011, my lord,
Thereafter in no,
2010,
No, 2017.
2007.
sir, are you prepared? Or
Right.
am I not audible?
My lord, I am prepared to the extent that their name should
Sent in the year?
2010 itself, my lord.
They were first sponsored in the year 2010. Respondent number 7 and 8
Yes,
or 6 and 7.
6 and 7.
We will record your submission.
Is it not?
Mr. It note for it. Mr. S.S. Goswami submits
My lord, kindly see the
that
document.
the names of the name of the respondent number 6 and 7 were sponsored for provincialization in the year 2011 itself. Who appears for the director of for the government here, for the provincialization authority, Mr. Das? He says the names were sponsored in 2011. Why did you provincialize in 2017? Why did it take you 6 years? Can you find from your whatever documents you have, whatever instructions you have? DLC report of what date? The fourth candidate was sent on the second round. One was the first round sent. Under 2017. Huh? When will you have the document? The entire records regarding the provincialization of each of the persons of that college. When will you have it? Huh? Somehow this court has forgotten calculation in days. It is only weeks and months. 5 days a week. Huh? 2017. Provincialized in 2021 for this college. Huh? Rate the college. Go and rate the college. You will find all documents. You don't have to sit in your director's office to wait for the documents. Go and read it. You have an inspector of colleges or something? No. Who's the person at the district level?
Inspector of schools.
Who looks after the colleges?
The colleges, there is nobody in the district, but when the provincialization matter were considered, they went through the inspector of schools only. That was extra power was given to the inspector of schools at that point.
At that point of time.
Yes.
Now, who can get it from the college itself?
The college.
The instructions are not complete.
My lord, may kindly come to page.
The persons who have been provincialized say that we were sponsored in 17. He says sponsored in 17. He says definitely sponsored in 2011. What do we do?
My lord, kindly come to page 55, my lord.
Oh, yes. Page 55.
My lord.
Okay. Again, let us
My
see page 55. Yes. Yes.
Serial number 2.
Ah,
Serial number 2 is the response number 6.
yes.
Mridusmita Gogoi.
Ah, sent
In-
when?
Last underqualified.
Sent when?
Under 2011 Act, my lord. They were declared underqualified, not disqualified, not disqualified, my lord.
Yes.
Next, serial number 3.
This is under 2000.
11.
When is it? Where is it? Where do we find it is 2011?
My lord, degree college in the next page, my lord,
Just a minute.
56. Next page 56.
No,
last.
this is a part of what? This is a part of what?
My lord, may kindly see come to page 56 in the last
Oh, Ram.
last line.
You are reading page 55.
55,
Huh?
my lord.
55 is a part of what? Part of which document? Five has to have something prior to that. It cannot start with the table.
If this submission cannot be a part of 2011, as my lord, in the first line, it is for a teacher and tutor. In 2011.
Come to page 49.
Seventeen Act. 17.
And he's saying this 2011 underqualified. Huh? He will not only bulldoze his own case, he will bulldoze your cases also now. Huh? Entire boat, lock, stock and barrel, what they say. Very sorry state. Very sorry state.
Indeed.
My lord, I think your lordship is also aware that the record has to be with the DHE, my lord. Has to be, because if it goes to the state level scrutiny committee, then it comes back with the final recommendation and approval of the government to the DHE
We are only trying to understand from Mr. Goswami whether he can defend at all or not.
Yes.
My lord, on earlier occasion, my lord, a bunch of paper was submitted before this honorable court.
By?
College authorities, my lord. Application for provincialism, this one, my lord. If lordship peruses page 10 of this compilation, if it is there, last of
Let us see.
I think my learned senior, my lord, referring to this, my lord. This one, my lord.
It is of which year?
Yes,
It is under which year?
Page 10 relates to 2011. Page 10, mid-90 period.
This is the application.
Yes, page 10 of that compilation. The 2011, my lord.
Page 10.
Page 10.
Yes.
It's a statement showing the eligibility of post. This is 2011, eh? And my lord, it turns to
That does not contain the name of.
Here the name of Punya Gogoi is appeared, my lord. If lordship peruse of page 12, there the names of
These
6
two
and
persons.
7 are there, my lord, underqualified. I think my learned senior is referring to this, my lord.
He's giving us a page number which we are finding in the writ petition. Are we not? In the records of the writ petition, we are finding a page. He does not have that copy, sir. You are trying to give a grain to the sinking person. Tinka is not working. Tinka is not working. And there down below, you will see the page that you are showing. What is down below?
Page 12, my lord.
At page 12, what is this? Whose signature is it supposed to be?
Director of.
So it is not something submitted by the college. It is something which requires the signature of the director, is it not? These 1, 2, 3, 4. These 1, 2, 3, 4 at the top. These are numbers given by them. Is it not?
Yes, ma'am.
And do you see that even if we take that 10, 11, 12 are part of the application, can you have a person's name missing in that format? He may be a qualified, underqualified. Your names were sponsored. Let us understand this much. We will ignore his allegation that it was because of a family relationship. Right? We'll take them to be the most honest persons. In the format, your name goes, although you do not have that 7 years, your names are sponsored. that one name is hidden. It is not sponsored. Why is that is what we are trying to find out. Sponsoring your name, if we take this page 12 to be the correct document, it again goes against you. Because your names were sponsored when you are not qualified. Why was his name sponsored as not being qualified? He should have been sponsored as an unqualified person. Can you make him vanish from the school? Houdini couldn't do it. Houdini could not do it. Man. He used tricks to make himself disappear and reappear.
Resolution if my
Oh.
comes to me.
Any resolution
I'll try to,
from Dibrugarh?
from Dibrugarh, I will,
Wednesday?
well,
This Wednesday, can you get it?
Wednesday, next Wednesday,
Today is Thursday.
Thursday.
Friday, Saturday, Sunday, Monday, Tuesday, Wednesday, perhaps holiday is niki? 27th is a holiday. But I am told it is now 28. Now it is 28. It is not 27. Shift hobo 28 में टाइम 20 shift होता है किन्तु 27 to non holiday declare कोई नहीं की
My lord,
हाँ
I do not know the reasons my client is not receiving my phone calls, I'm not replying, I'm not getting last
kindly see
instance.
page 8 of that application. Kindly see page 8. Yes, sir. Kindly see page 8.
Yes, madam.
Three of them, Department of Economics, Punyo Gogoi, Midusmita Gogoi, Mosumi Gogoi. Why is that other lady's name not there? She is underqualified. She was not qualified to be sponsored, correct?
My lord.
Why did you sponsor Midusmita and Mosumi?
Because at that point of time, they secured the highest marks, my lord.
Why did you send them names in the provincialization application form?
Yes, my lord.
They were not supposed to be provincialized.
Yes, my lord.
Why did you send their name? If you have taken a resolution not to send underqualified people. We are going, if, I'm being very clear, if petitioner succeeds, entire salary comes from your coffers, not the government.
My lord, we are not drawing salary, my lord. 6 and 7 are not drawing salaries. We are not paying them.
You will pay because you kept her hanging. You kept her hanging. You are 6 and 7 not paying. You are not being paid salary 6 and 7.
My lord.
He's 6 and 7.
No.
7.
He's 6 and 7.
No, I'm principal, my lord. We are not paying their salary. My lord, kindly one point. My lord, may kindly see one point. From 29 2020. From 29 2020. The petitioner is not attending the college, my lord.
We will see to it that for the last 5 years,
My lord.
she will face a disciplinary proceeding for not attending college. We will allow you to hold a disciplinary proceeding against her. That will do.
My lord.
That is an indisciplined act.
My lord, we have not got it.
She was your employee.
My lord.
And she has not attended college for last 5 years.
My lord.
Indiscipline.
My lord.
Hold a disciplinary proceeding. The moment you admit that she was your employee,
My lord.
you have to answer why you did not sponsor her name for provincial course.
We have not.
There are 2 ways of doing it.
My lord.
Shoot a person, then say that we have got these many complaints against him. And you can place all the complaints before and say, okay, we are now going to shoot him. There are 2 ways of doing it. You have shot him. And now you are trying to justify by entry 66 of the Constitution. Do you deny for once that she has taught in your school in your college for 30 years?
No, I cannot deny.
You cannot deny.
My lord.
Were you the authority to decide who is eligible for provincialization and who is not? No.
My
You
lord,
are supposed to send all the names of all your employees.
my lord.
District level scrutiny committee will look into it. You not only try to decide whether she is qualified or not, you go one step more. You decide she is not qualified and you do not sponsor the name. Now that basis of the decision will be required. If you do not have a basis of that decision, as to why her name was not sponsored, but other unqualified persons were sponsored. If there is nothing on record to show that.
So, my lord, may allow me
Friday?
note at least 10.
We will not have a confusion on Wednesday and Thursday. Friday?
My lord,
Next Friday?
my lord, respond number 6 and 7 has a connection with the college, my lord. They are not receiving my phone calls. I am not getting instruction also. I may be allowed 10 days time at least.
Seven's connection is admitted.
I do not know.
You were engaged by whom?
I am engaged by the
6
president.
or 7?
Huh?
6 or 7?
No, I was engaged by the president governing body. And I appeared for respond number 3, 4, and 5. And
So we should direct the respondent number 6 and 7 to bring the records.
no, I will bring it, my lord.
Huh.
Yeah, I may be, since they are not receiving my phone calls, I'll write them a letter, my lord. By speed post, I'll send it.
Mr. Deka, I think we'll keep it for Tuesday. Close the matter. Any further humiliation required? The best that we could do. Do you agree that in 2017, when your names were sponsored, her name should have been sponsored? Qualified, underqualified, eligible, not eligible, forget it. We are talking of sponsoring a name. There are so many persons here who were in the court number 23. Would I miss out someone's name? Can I miss out? No, I have to give everybody's name. These are the persons. And these were appearing. Is it not? Could her name be missed out? Dropped?
For consideration of
It could not have been done.
consideration.
We are asking an honest reply.
For consideration.
You may be more eligible. We are not deciding that. She may be ineligible. We are not deciding that. Only point whether the name was required to be sponsored. Yes. If so, who is the proper authority to take a decision? DLSC, SLSC, government
Government will
comes
take
back to the director and you get whatever you need to get. The provincialization has to be kept on hold. Her name has to be considered with whatever qualifications she has. She will be heard. You need not be heard regarding her case, whether she is qualified or not. There is a decision between the government and the, right? The moment her case is considered, rejected, your order as it stood in 2021 continues all benefit. Moment she gets a benefit, whosoever is out, will have a case. Or before granting her and removing the other person, it is at that point of time a notice will be given that we have found this difficulty in your provincialization, kindly come and answer. Then she would answer. If she is correct and he is correct, there will be 4 persons in the boat. If one of them has to be rejected, it will be rejected. Should we linger this on for some more time or should we do this on Tuesday? On Tuesday? We are not in. Huh? Tuesday is what?
Today is 8 I.M.
Eid. 29? Who is going? We are talking of 26.
Puri bolo.
You are talking of second. 26, we'll just have to pass the orders. We'll just have to pass the orders. We are not saying whether you are qualified or not. Or respond, you are for respondent number 7. And you are? And you are for? So 6 and 7, we are not interfering with your provincialization as such. It has been kept in abeyance till the decision of the competent authority, kept in abeyance. Her case would be considered as if it was sponsored along with you.
My lord, in limited time frame.
They will consider whether you are supposed to be provincialized or on this 54.5, 55, whatever it is there. If your name had been sponsored in a particular manner, it would have been considered in a particular manner.
This is good, by the way.
Is it not? Get
But
that?
my lord, only one thing, if your lordship appreciates,
Oh,
from 2021.
you will get your benefit from 2021.
No, but another thing, I'll tell my lord, this is the practice now going on. Going on means, it's very sorry to say, as only 6 months left, if your lordships look at, leave it to them, they will not do anything, then I have to come for contempt and everything will go, my lord. Is only thing that 54, whether government.
Do not put that issue
No, I'm not
for
putting,
us.
I'm not putting,
Do
I'm
not put
putting.
it before us because
I'm put.
we direct something today. Will they do it tomorrow?
No.
We grant you that relief. Will they do it tomorrow? No. Where does it stand? Either for you to come back or they to go a few steps more.
No, only thing is that I have got
See?
that
Either of the two is. Now,
alternatively there is something, my
to
lord.
find out your eligibility or otherwise, are we to do the inquiry process?
No,
Hopefully not.
no,
Then,
I'll never say that.
then
Only thing is that when the government notification is there clearly,
we'll
Till-
record all that, and that
till-
is why
no,
we
no,
will. That
till-
is why we will have to send it back.
I'll leave it to your lordship.
The notification is there that 54.5 you are eligible.
Yes.
55 you are eligible to taken as 55. Your rejection is on the ground of 150. That goes because you are not supposed to be considered as the fourth person. You are supposed to be considered as the second. When you are being considered for the second, 150 question will not come in.
Obviously, my lord.
Therefore, we will keep that in mind. We will give these details. And then we will say that they will consider your eligibility for promotion, for provincialization on whatever else is there in there. If you are not eligible for some other reasons, we do not know. But these two reasons we will set aside. And you will be considered as if you are the second teacher.
My lord, let it be on Tuesday.
My lord, today it can be disposed of, my lord.
No, today we have to do some shorter matters. This will require a lengthy discussion. I will have to speak a lot. And others in the court would be waiting.
Tuesday, my lord.
It's like,
Tuesday.
it's like serious.
Tuesday, unless you come up with some magic.
My lord, the government will take the decision,
Huh?
my lord. No.
Is it not? But then you have to keep in mind that he has got 6 months to go. So we are giving you a very short margin. Who? You will take on record whatever is there. He will send you he will give you the documents. Petitioner will give you the documents. You will only verify. Everything. You verify from the Dibrugarh University, whichever university, he will get whatever certificates he wants. He will put all the documents in original before you. Take a decision. Finish it. Place it before the DLC, SLC, whatever C you want to put it. Whichever C you want to put it to, put it in that C. Let us see if he sells. Tuesday, Tuesday, any get us. 26. I'll come back in 5 minutes.
That's a service matter.
Hmm.
The challenge to the punishment order of
Ah.
reduction in rank. My
Ah.
learned friend has filed the counter affidavit today itself. They have
Hmm.
given a copy to me.
Hmm.
So Lordship sees 29th of April order.
Hmm.
The original records also they have to submit to your
Hmm.
Lordship. So if he has filed it today only, so I will need some time to go
Okay.
through it. Can it be after 2 weeks?
The counsel for the appearing for the respondents has submitted that, and counter affidavit has been filed.
Today.
Copy has been served upon the learned counsel appearing for the petitioner. The learned counsel for the petitioner acknowledges the receipt of the affidavit in opposition and seeks an accommodation to have his instructions on the same. Place the matter again on
Second week of June or first, whatever convenient, Your Lordship, because
Do not be there.
he's retiring next year. That's why there was a
Do not be
specific date fixed.
12th of June. 12th of June?
5th of June, yes.
12.
12th, great.
12 of June 2026. The learned counsel for the respondents shall keep the records
Yes,
of
sir.
the disciplinary proceedings ready for perusal of the court on that day.
Grateful.
My lord. There's one more item, number 20, 35, my lord.
Yes, sir.
30, my learned friend said after 3 there were difficulties in another court. So
Hmm.
there's no point of, my lord. Can it be on 28th? They agreed on 28th, my lord. That co-warrant to petition. Although
Item 35, you said.
35, yes.
This is matter on the 28th of
28th.
May on a joint request by the counsel for the parties.
Oblique.
VC, কি রে? এই VC টো কৰি লওক। VC টো কৰি লওক, free কৰি দিম। Delivery for this will take time.
Wait, please, my lord.
Yes.
I seek your lordship's permission to address through VC, my lord.
Yes, yes.
Yes.
We'll
Well,
just file. Just a minute. We need to have the file.
Lordships. Lordship, before my learned senior started, Lordship, I
Hmm.
have some submission, Lordship. My limitation, Lordship, it is clearly my limitation of my office, Lordship. So for Lordship, in the branch of cases of APSC, Lordship, related the survey,
We are not on the merits, sir.
Lordship.
It's just a formal application, my
Have
lord.
you seen the interlocutory application?
Yes, Lordship.
What does it say? It is seeking permission
No, Lordship.
to amend the writ petition.
The amendment, no issue, Lordship. Amendment.
Is it not, sir?
Yes, yes, my lord. In fact, it's a very formal application, my lord.
Lordship, I have no objection, Lordship.
Just a minute.
Otherwise, Lordship, the additional Advocate General, Senior Counsel, Nalil Kulli will be.
No, there's the amendments
What
paid
is
for
the amendment?
amendment are at paragraph 8, page 6, if your lordships have, my lords. This, my lords,
Objection.
if I may just give your lordships a background, my lords.
The paragraph 4 to 6 of this IA.
Paragraph 8, my lords, at page 6 are the amendments which I am praying, my lords.
Hmm.
If your lordships have, my lords, I hope your lordships have IA number 1654.
No, I have 1343.
That we are not pressing, my lord. That your lordships may dispose it of, my lord. We have 16354, my lords.
1635 to give Arohana IS.
1654.
1654.
Yes.
Yes, what is this? Let us see the give me a minute.
It's at page 8, my lords.
Hmm.
Just where I'm seeking, my lords, leave to amend the writ petition. Add paragraph 36A and C and a ground, my lords, and to amend the prayer.
Okay. Now, do you have any objection for amendment of the writ petition?
No, Lordship. No, Lordship.
We'll allow it.
Very
Who is
well. I'm
not
grateful.
objecting?
I'm grateful.
Because it is come in the hearing list, Lordship. Therefore,
Well, sir.
No, he will have to file a fresh
We'll do it. We'll do it by tomorrow, my lords, because they have still not filed their counter.
We will give you the liberty to file your
Lordship,
reply on those amended part.
Lordship.
No, they have still not filed a
Yeah,
counter
yes,
to the
they
main
have
You
writ.
have not filed a counter.
Yes,
then-
I will file. I will file. Therefore, I want to take the
Huh.
leave from the court.
Okay,
My lords, just one correction, my lords.
yes.
That at prayer, if your lordship see, my lord, the prayer 3A which is sought, it should actually be, my lords, prayer BB. We are adding prayer BB instead of 3A at page 8. It should be BB. Small
You are
b.
seeing, for the amendment of the present writ petition as mentioned at para 36.
Yes. Then, my lords,
A to
ground
C,
F. Yes, my
ground
lord.
FF and prayer outline herein above.
Yeah, it should be, my lord, prayer BB instead of 3A. I'm sorry, my lord, that's a typographical error which came in. Small b. At page 62, the prayer act.
The now heard Mr. A. Chaudhary, learned counsel appearing, learned senior counsel appearing in the matter assisted by. Stop this present. I also heard Mr. J.K. Goswami, learned counsel appearing for
Lordship, I'm appearing
the senior government advocate.
For the respondents.
all the
All the
Yes,
respondents.
all
Yes.
the
Stuff. This interlocutory application has been filed by the writ petitioner seeking amendment of the writ petition number 5344 of 2025
Yes.
at paragraph 36 within bracket small a dash within bracket small c comma ground FF and the prayers made in the writ petition, full stop. For ease of reference, the proposed amendment are reflected herein below. Stuff, okay. वो देखिए, you'll take from page 6, paragraph 8,
To 9.
from where I have given the A mark to paragraph
9.
end of paragraph 9. Okay.
Just that small correction, matlab BB in place of 3A at para 9, my lords. At both places, my lords. BB.
9, main prayer, after the main prayer, on the following prayer may be added.
Yes.
There is
BB.
there is a at
Three.
page 7. No, we'll keep it as it is. Learned senior counsel has submitted that there is a typographical error in as much as the prayer which is required to be added on the amendment should have been numbered as prayer B
B. After prayer
Again
B.
B.
But yes.
after paragraph B.
Yes.
The learned counsel representing the state respondent has submitted that the state would not have a objection for allowing the amendment sought for. Full stop. Accordingly, this interlocutory application is allowed. The petitioner would file an amended writ petition by and shall serve requisite numbers of extra copies upon the state respondents
By tomorrow we'll do it, my lords. It's ready.
within a period of 2 days from within tomorrow.
Yes. Good.
IA accordingly disposed of.
My lords, the
Now-
other IA I'm not pressing, my lord. That your lordships may.
Then you take down
Withdraw.
this IA number
This is separate.
1343 of 2026. Huh?
Yes.
Learned senior counsel has submitted that he is under instructions not to press this interlocutory application. Accordingly, the same is closed as not pressed.
Very grateful.
In the main writ petition, you write, today by an order passed in IA 1654 of 2026, comma, an amendment to the writ petition has been allowed. Full stop. Petitioners have been directed to file the amended writ petition by tomorrow. Full stop. On receipt of the amended writ petition, the respondents would be at liberty to file their response to the amended writ petition. Full stop. Any fixed date earlier?
Yes, my, if your lordships can fix it, my lord, in the second week of June or whatever your lordships.
Third week of,
third week of June.
you take a, you choose a date.
Lordship, it is 19, Lordship.
At the request of the learned counsel appearing for the state respondents, comma, giving him opportunity to file the response to the amended writ petition, list the matter again on 19th of June.
For hearing, my lords. I'm grateful. Very great. Very good.
You should not, unless the council sir here. You should not.
May I please, Your Lordship?
Yes, madam.
Lordship, in this matter, Counsel M.K. Sharma is unable to appear today due to some medical emergency, Lordship. So matter may be taken up on another day, Lordship. And today is fixed for obtaining instruction by the department.
Mr. Bigogo is supposed to appear, my lord. He's on legs, my lord. Matter can be
In
taken up
the
on,
absence of the
my lord.
petitioner, what can we do?
Yes, your lordship. Lordship will take it up on Tuesday, my lord.
Tuesday, fine.
For the hearing, my lord. Already you have lordship has heard at length. Tuesday, my lord. In the meantime, we'll place.
Ah,
This is that case, my lord. That
Retrospective promotional benefit, Lordship.
an accommodation has been sought for on behalf of the learned counsel for the petitioner for the day and stuff. It has been submitted by the learned counsel for the respondents that the instructions sought for are available.
available and will be produced on Tuesday.
Unless the matter again on Tuesday, we do. For further hearing.
For the hearing. Deeply obliged.
Obliged.
Further hearing.
Tuesday.
Full-
Tuesday.
এটা কি admission মাতি আছে? Admission এর মাতি।
May please, your lordships.
Hmm.
It is appearing for minimum of pay.
Are you filing an affidavit, madam? No.
My lord, we have not filed, we have not received any instruction as yet, my lord.
Ah,
So, my lord, at least 3 weeks' time may be granted so that we can file our affidavit.
Minimum pay scale lordship is
huh? Pay scale.
claim for minimum pay scale.
Without their affidavit as to whether you are serving or not, at what stage are you serving, it will be difficult. Heard Mr. Swins, your name is?
Yeah.
J.U. Ahmed, right? Counsel appearing for the petitioner. Also heard Ms. P. Chakraborty, and the counsel appearing for the respondents. Ms. Chakraborty has prayed for an accommodation of 3 weeks to file the affidavit in opposition. Full stop. The matter is of 2024 and relates to the grant of minimum, grant of pay at the minimum of the pay scale. Full stop. Granting a final opportunity to the respondents to respond to the writ petition. List the matter again on July the first week. Or second week. 15 July.
Lovely.
Yes, sir.
May please, lordship.
We have to select a decision of the authority on the ground that we have participated in selection process issued by Deputy Commissioner Nalbari, Commissioner Nalbari, for selection of lot mandal, 18 number of lot mandal. We have prepared the selection process. We have been, Lordship, we have qualified the written test, and thereafter we have been called the Lordship, the computer proficiency test. And thereafter, Lordship, one repetition has been filed challenging the selection process on the ground that, Lordship, as per advertisement, 1:4 candidates should be selected. Page 30. Lordship, kindly see page 30. 28 is the advertisement. Lordship will find the advertisement condition is at page 25. Lordship, kindly see page 25.
Yes.
Page 25, serial number 7.
Ah.
Against each vacancy, 4 number of candidates will have be shortlisted on the basis of marks obtained in the written test. On this ground, one repetition was filed challenging that 1:4 ratio has not been followed. Lordship will find now the order passed by this Honorable Court in the said repetition, page 30. Lordship got it? The order is dated 4/4/2023. Now, Lordship, the Honorable Court heard the matter after going through the records and finally page 35. I have perused
Against 7 posts, 28 candidates were called for.
So I have perused the result of who participated in the written test as well as the marks obtained in the shortlisted candidate. The fact that the petitioner who belongs to the unreserved category, there are 28 candidates who have been shortlisted against 7 posts. This court does not find any reason to interfere with the instance petition. Herein, they could not question the selection of 28 candidates were shortlisted against 7 unreserved posts in the terms of clause 7 of the advertisement. Consequently, instant petition dismissed. Thereafter, same condition, another petition filed in 2024. This order is 23. This is 24. Page 36. Lordship got it. Here, Lordship, this Honorable Court at the motion stage, page 37, 25/9/2024. Order has been passed to the authority to remind the matter. Lordship will find the relevant portion. As the advocate, senior government advocate, submits that basis of written instruction dated 16/8/2006 that since only 52 candidates have been shortlisted to fill up 18 posts, ratio 1:4 as per requirement of the rule was not fulfilled in this case. Therefore, district administration has sought instruction from the government Assam as to further steps that is required to be initiated in this case. Lordship, thereafter, this Honorable Court forwarded the record to the authority to take a decision. Now, Lordship, the authority has taken a decision, page 39. They have cancelled the selection process. I am on that. Lordship, there is no allegation of arbitrary action. Only violation is 1:4. Whether the selection process is vitiated or not following 1:4. That has been already decided by this Honorable Court in early writ petition. Second writ petition, the earlier order was not placed before the Honorable Court.
But then the number of posts is different. It seems there is on the earlier writ petition, it was an allegation of 7 posts.
No. 18 posts. Total posts is 18. 7 for unreserved. Same advertisement. Same advertisement. Now, on the basis of the remand of the order, they have passed this order cancelling the whole selection process. I am also not selected candidate. I am not a party to the case. And because of this order, I am affected.
How?
Lordship, they have decided to make a fresh selection on the basis of the remanding the matter. Already this court has upheld the selection process. Now they cannot take a fresh decision. And Lordship, this selection.
That will require a review of the earlier order.
Lordship, I have already filed a
1505 of 2024.
Already, I have filed an application for review of the order because that has been pointed out. I have already filed an application of the abandoned question. I have already filed an application for review of the earlier order.
Let both be taken together.
Lordship.
Unless that order is recalled.
And Lordship. And Lordship, in this matter, I apologize that I have gone through a full bench judgment of the Supreme Court. Where Supreme Court has categorically stated that earlier decision was that in a selection process, I have no right to get an appointment. selection is the procedure, this decision whether government will fill up the post or not is for the government. But when selection has been made by the authority, they cannot abandon the selection process in the meantime. If they do not decide to fill up the post, then otherwise. Otherwise, they cannot.
But if you want to go for a fresh recruitment, it is not a case of abandoning the process.
No,
That is what
it is pre-selection is abandoning the earlier process selection process.
No,
They have
no,
cancelled
they
their
have not given up filling up of the post. They want to do it in a new way. That
New
you
way.
say is impermissible.
And that is why also Honorable Supreme Court says that the person who has been shortlisted in the earlier selection process, they have a right. Earlier Supreme Court has said selection is not a right. Appointment is also not a right. But full bench judgment, I have pointed out, place that, Lordship, on if the review application has come, Lordship. Lordship, the Supreme Court has said no. There's a
We'll have it along with the review petition.
review application.
That's
Huh? And you
First-
department, you know both the cases.
Lordship, yes, first petition which is relied, that has been filed by the general category candidates, 7 provision. Their allegation is that
Thing is this,
one is for
in that case, you take a stand
Lordship,
that 52 persons have qualified the written test.
Lordship.
We do not have 1:4 ratio.
Yes, Lordship,
You should have told the court.
Lordship.
You should have told the court that we don't have 1:4 because
Lordship, that has been
persons fail to qualify. Suppose
has been
suppose you are
closed.
giving 3 posts
Lordship.
and 2 persons apply. Or let us say not 2 persons. Let us say you have got 3 posts and 10 persons apply. 1:4 hoga hi nahi.
One,
It will never be 1:4.
but
So you'll say that no. 1:4, we have to get 1:4. So we'll go to candidates' home and pick them up and bring them and make it 1:4.
but that condition has been stipulated, that 1:4 has to.
Then why did you produce this? Where do
But
you take
that-
this sentence? Page 34, last.
Lordship.
Page 34, last line.
Lordship. That order has been passed on the basis of an
Please see the last line of page 34 before you. What does it say?
I have produced
Though
34.
in the advertisement, it was mentioned that 72 candidates would be shortlisted in order of merit.
Lordship.
Only 52 candidates qualified the written test.
Lordship, no.
So you proceed with 52. 1:4 will mean that you will not call in everybody. You will call in
Who qualified?
1:4. No more than that. It is for cutoff.
But that, Lordship,
It is for cutoff.
Lordship.
Mm.
But this case that has been filed by the general category
What?
candidate, Lordship.
The total number of posts is what?
18. 18 is
18.
to 4
For 18 should be 74.
72.
72.
Lordship.
Your stand in the earlier writ petition is that we don't have 72, we have only 52. This court says yes, 52.
50.
Out of that 52, 28 for general. So 1:4 complete.
But he is unreserved category.
Huh?
Lordship, OBC category.
Oh,
Petition.
oh.
No, hearing.
Even then it remains 52, 72 candidates. You cannot bring in more.
Lordship, that is true. But
You cannot bring in more. If there are 3 people in the OBC category with 1 post, the 4th person from where will you produce?
that is why most probably department has
Cannot.
decided not to proceed with this. Lordship.
That is you cannot. You should have done it even when the 52 was there.
Even though, Lordship, they only selected or
You want us to dispose it today? We can
no,
do
no,
it now.
that
We can do it now, notwithstanding the
reviewers.
other order.
Otherwise, Lordship, without reviewing this order, Lordship, Justice
Eh?
SCM, that is a patent finality, Lordship, that has to
No,
be
it
reviewed,
is,
Lordship.
I will tell you why. You are supposed to take a decision. Can the decision be against the law?
No, but
We'll say that you took a
Two option
decision,
has
that
been
decision
given.
is under challenge.
2 option has been given, Lordship.
That
Subsequent order, Lordship.
decision is under challenge.
Lordship, that is.
We'll set aside your decision. Or with the review. Tell us.
With the review, Lordship, let's take over. The subsequent order, we have department has given liberty to Lordship.
Your second order,
Second order.
your second order, that page 39 order.
39, so yes.
Being in direct contradiction with your stand taken at page 34. Only liberty was granted to you to do either of the two. Whatever you do, you have to justify.
Lordship.
You have done it.
Lordship.
You have done it. You have complied with this
We have
choice.
sorry, Lordship.
You have complied with the choice. Now the choice that you made is under challenge. Is it not?
Lordship.
So that order need not be interfered with. Why should that require interference?
The parts of the present document.
Did the court say that no, you should set it aside, we find it wrong? No.
No.
Court said you take a decision quickly.
That is
Do what you want to, do it quickly. That is what the court said. You took a decision, this is in contradiction with the earlier stand taken by the respondent before this court.
the earlier
A stand taken before this court will be upheld, yes.
that may be fixed with the review petition.
List along with review petition number.
Serial number
Review
5762. 5762 of 2026.
With review, list along with the review petition stated to be filed by the petitioners. Right, filing serial number so and so. We'll stop the direction to connect the review petition to this petition shall be subject to office objections being removed by the petitioner, if any, in the filing of the review petition.
Next week, Lord, sir.
Give a date next week. Next week, who took this? Huh? 28th.
Obligations.
Login query, go refresh question.
6.
Yeah.
May I please, Your Lordship. Lordship, in this matter, I'll be led by my senior, Mr. Didas. Due to some personal difficulty, he won't be able to appear today. Lordship, may I kindly fix a short date? Can it be on Tuesday, Lordship?
Short date is difficult on the next year.
There is some urgency in this matter, Lord. The petitioner will be retiring in the month of June.
Retiring, what is the discipline proceeding regarding? What was the penalty, or what was the penalty imposed?
The penalty was of compulsory retirement.
Then he's retired.
He will be retiring in the month of
He's
June.
retired. Already compulsorily retired. Is there a stay?
Lordship, it will be best if my senior addresses this court.
Is there a stay? No.
No, no,
So he's already retired. As of today, he's drawing pension. He's at home, happy.
Lordship.
If he reaches the date of superannuation during the pendency of the case, what will happen?
Lordship, may I kindly fix it on
He will be set aside, entitled to all back wages and everything.
We'll satisfy your Lordship on Tuesday.
Yeah, Baru. Retirement Pravati. It has been submitted by the learned counsel for the petitioner that an accommodation will be required as the leading counsel is unable to appear before this court today, full stop. He has also submitted that the petitioner will be retiring in the month of June.
Lordship.
2026, accordingly, release this matter again on. He'll retire in June.
June, in the month of June.
29th.
Oh,
29th of May.
Then we find Lordship. Much obliged.
Lordship, here they were declared unfit on the medical ground, Lordship. After review examinations. Then, Lordship, they were underwent medical examination in
some other hospitals, Lordship, where it was found that they were normal.
Lordship, in this case, Lordship, we received our instruction yesterday, Lordship. If some affidavit are required, then 2 weeks time may be given. Otherwise, similar order is there, Lordship, page number 113, Lordship.
Even if similar order is passed,
It's
it's
passed,
not true, Lordship, because this court has already taken care of it. Giving one more opportunity to the petition to face the medical examination. Lordship.
You agree to this similar order?
Yes, Lordship.
Heard, Mr.
M. Ahmed.
Counsel appearing for the petitioner also heard. Miss,
Are they appearing on behalf of SS Roy, Lordship?
appearing for the respondents, all the respondents?
Yes, Lordship.
All the respondents, full stop. The petitioner had appeared in an advertisement published by the Staff Selection Commission on 5/9/2024. क्या बोला? The petitioner had appeared in a selection process. Take it down afresh. The petitioner had participated in a selection process which was initiated by an advertisement published by the Staff Selection Commission on 5/9/2024. Full stop. The petitioner had completed the computer-based test as well as the physical efficiency test and the physical standard test. Full stop. However, he was declared unfit in the detailed medical examination on the following grounds. Synopsis part from A to A. The learned counsel appearing for the petitioner has submitted that in similar situation, this court had passed orders dated 18/11/2025 in WPC number 5952 of 2024, granting the following relief from page 115, para 9 and para 10. The learned counsel for the petitioner has submitted that the grievance of the petitioner for the present would be redressed if a similar direction is issued in favor of the petitioner also. Full stop. The learned counsel appearing for the respondents has submitted that they would not have any objections if a similar order is passed. Full stop. In view of the above, this petition is disposed of, granting a relief similar to the, granting the same relief to the petitioner in this present petition as was granted to the petitioner in WPC number 5952 of 2024. Full stop. The order has been passed in the presence of the councils and with their consent. Full stop. The petition accordingly disposed of, no order as to costs.
Obliged, Lordship.
Sorry, Lordship. Item number 5, there is an interim order, Lordship. That may be continued, Lordship.
Item 5, what is it? Interim to continue. Item number 5, there will be an interim to continue.
Obliged.
Please, your Lordship. Lordship, I need some more time to file a affidavit, Lordship.
Lordship, the basis on which the dismissal order was passed, the
the conviction has been stayed by the appellate court. Okay, I'll.
Conviction has been stayed or sentence?
Sentence and conviction both.
Where is that order?
Additional affidavit, Lordship. Page 85. Para 13, relevant portion 87.
But it has been stayed after the orders had been passed by the.
Yes, Your Lordship.
Heard Mr. So-and-so and counsel paying for the petition. Your name, sir?
MBD, Your Lordship.
M. Berial and counsel paying for the petitioner. Also heard.
Lordship, kindly consider my interim prayer.
So-and-so and counsel paying on behalf of Mr. K. Goel and CJC, who prays for an accommodation to file the affidavit in opposition. Have you received your instructions, madam?
Yes, Lordship.
Since the instructions have been received, full stop. The affording such opportunity, list this matter again on when can you file it?
Lordship, 2 weeks, Lordship.
Give us a date. Choose a date.
So, Lordship, June,
18th?
yes.
18th of June 2026, full stop. What was your interim prayer?
To suspend the effect and operation of the impugned dismissal order.
Dismissal order?
Yes, Your Lord. At least I may be suspended. Because I was terminated, I may be suspended till next day.
The petitioner has renewed his prayer for suspension of the order dated 16/12/2025, full stop. The learned. This court is of the opinion. And the learned counsel has submitted that since the order of conviction has been stayed by the appellate court, the interim prayer of the petitioner may be considered at this stage. Full stop. The matter is one of dismissal from service by order dated 16/12/2025 on the basis of the conviction of the petition.
Yes, that was the.
Since the have you served a copy of the additional affidavit on the CGC?
Yes, sir.
Since the copy of since the respondents have been served with a copy of the order by which the conviction has been kept in abeyance, it shall be open for the respondents to reconsider the dismissal of the petitioner, since on the basis of merits of the appeal, the conviction has been kept in abeyance by the appellate court. Full stop. List again, as stated before. The decision of the respondent authorities with regard to the reconsideration of the dismissal order, if any, shall be placed before this court on the next date of hearing. Full stop. The petitioner is allowed to renew his prayer on the next date of listing. Again, full stop. The respondent shall ensure filing of the affidavit in opposition before the next date of listing.
Listen.
Well, at the petitioners before your lordship are that teachers and their GPF amount was not released. Despite of the fact that there is a decision of this honorable court and the government has also issued a letter which the lordship will find with my additional affidavit, page 78.
You are not responding to the same? You will not file any affidavit?
But my lord, the GPF amount detected by the account general. So let them.
Is the accountant general a party here?
My lord.
Who appears? You appear? Yes. You have deducted their GPF amount and you have not deposited anywhere. Criminal misappropriation of property. Have you not used that term? Huh? Yes. Tell us. Who?
Estimate.
Where is he? He's on legs.
So
Sir, admittedly, this page 78
Hmm.
of the additional affidavit, this order we could lay our hands up later on. This is to the Secretary of the Government of Assam Finance Department for regarding refund of the employees' contribution with interest for employees converted from NPS to OPS. And the judgment rendered in 2000, reported in 2023 GLT is very clear.
No, your money was deducted in GPF.
In GP.
Your GPF contribution was deducted. Then you got a letter saying that you are in the new pension
New
scheme.
pension.
Now the government says, no, you'll be in the old pension scheme.
Because of one judgment of the Purnima.
Purnima. Then when you get your new GPF numbers, your allegation is that the money has not come
Not
to
been
the
redeemed.
GPF
Not been redeemed.
account.
Yes.
Who is to give it? The accountant
Then
general.
the accountant general.
And the accountant general is not giving it.
On let's.
Do you dispute that they have come to the old pension scheme? No. So if there is a direction to the accountant general to refund it within a particular period of time, the writ petition is over. Mr. Borpujari, any objection of the finance?
No objection as such, my lord, but page 70, they have made a representation before the Director of Accounts and Treasuries. Because the Director of Accounts and Treasuries is the authority who is responsible for, my lord, keep the accounts and track of, my lord, the contributions made under the new pension scheme. And there is a prayer in the writ petition, my lord, for disposal of that representation.
No, whatever has been deducted by the treasury, who is the Director of Accounts and Treasuries?
Yes.
Under the NPS, that now requires to be sent to the GPF account number allotted to the petitioners individually.
Yes.
We don't need a disposal of such kind of a representation. They have said, please do it early. What kind of a representation, what representation will be disposed? When the admitted position between the petitioner and the concerned department is there covered by the old pension scheme. NPS was wrongly deducted. Not wrongly, NPS was deducted on an erroneous presumption that they would be under the NPS.
Yes.
Now this contribution is with the treasury.
Yes, Director of Accounts and Treasury.
Director of Accounts and Treasury.
Yes, no,
We will give a direction to the Director of Accounts and Treasury that on being furnished with the new GPF numbers allotted to the petitioners within a period of 45 days, arrangements will be made to refund the amount to the or to transfer the amount to the GPF account of the petitioners individually, whatever was deducted. And we'll direct the accountant general to transfer the initial amount recovered for the GPF to the new account numbers allotted to the petitioners. That is your prayer.
That is the prayer, but one or two repetitions of similar nature came up before this honorable court. Now there I had taken the instructions. Instructions are to the effect, my lord, because under the new pension scheme, there is a fully established automated system. And that is controlled from, my lord, the National Pension Portal system in Mumbai. Now it is a centralized system. Now in this kind of a situation where, my lord, the contributions are deducted on account of being covered under the NPS by the authorities, later on it is found that, my lord, the person concerned comes within the ambit of 1969 rules. Then, my lord, what would be the procedure? Because once
No
it
one
is-
knows what is the procedure.
Yes, to that.
Start it.
No, therefore,
Someone has to start it.
yes, therefore, my lord, the Director of Accounts and Treasuries have made a detailed representation before the Finance Department to lay down the guidelines, and that is, my lord, awaited.
Would do.
That
We
is-
will pass
that
an
is-
order if it cannot be done within the time frame given by the court. Concerned those two authorities will come before the court to say we will need some more time because the finance is laying down the guidelines. But would keeping the repetition be of any use to anybody? That money has to go back.
No, money has to go back. She is getting, the petitioners are not deprived of the old pension scheme. All the benefits are
Okay,
flowing.
money
to
is inside some other
them.
account.
For some period, money is there.
Hmm.
It is not the case of the authorities that the money will not at all be refunded or it is forfeited. It will definitely.
So what do we do with the
revert back
repetition?
because of the centralized system. That is.
So what do we do with the repetition now? We dismiss it.
If Lordship keeps the repetition pending for some time and accommodate me, my lord, I will take the instructions.
Regarding the
Regarding the
guidelines.
system that is going to be put in place now to
What is
tackle
that
with this
document you are
kind
showing
of
us?
this
My
kind
lord,
of
this
issues.
is the document of 2022, May 2022, how they have disbursed the money. This is the document.
They have disbursed the money also.
Yes, to others, not to us.
Then I will have to take instructions on facts, my lord.
You have nothing to do. Finance department in this matter, what to do? Already refunded to others.
Already refunded to others, my lord, under what situation, I do not know. Therefore, I am praying. This is a 2026 matter. If Lordship accommodates me for 3 weeks' time, let me come up with some instructions, my lord. Because my file says, my lord, we have not sought any communications. Therefore, let me make the communication and assist this honorable court, my lord.
Yes, Mr. Medhi, what do you say? You deducted money in the old account, old GPF account, yes?
Yes.
Now they have a new GPF account. What is the difficulty in transferring the money to a new GPF account?
No. We reopened a new account.
They have
New pension.
reopened that account, no? You are not deducting their money, is it?
Yes.
They are not you are not deducting the money. Why? Hmm? Heard Mr. Learned Counsel appearing for the petition. Also heard Mr. Arbor Pujari, Learned Counsel appearing for the Finance Department, and also full stop. Also heard Mr. Talukdar appearing for the Department of Education, and Mr. S.K. Medhi, Learned Counsel representing the Accountant General. Full stop. The grievance raising this petition is that the petitioners, no, that some amount of that their GPF contributions were earlier being deducted by the Accountant General since they were covered by the old pension scheme. Now, by the pension rules of 1969. Full stop. However, for a short while, under a misconception, no, however, for a short while, they were taken to be covered by the new pension scheme, and accordingly, their contributions under the new pension schemes were being deducted by the Directorate of
Directorate of Accounts and Treasuries.
Accounts and Treasuries.
Well,
Assam dispute. Full stop. The petitioners claim that now their GPF accounts under the old pension schemes have been reopened. and their contribution is required to be deducted by the accountant general and deposited in the same to ensure their service security, full stop. The learned counsel has submitted that in similar situations where NPS contribution had been wrongly deducted by the Directorate of Accounts and Treasuries, the said authority had refunded the money into the accounts of the employees for conversion from NPS to OPS, full stop. The learned counsel for the petition has submitted that the accountant general is now required to start deducting their GPF accounts, their GPF contribution, and the money already deposited with the Directorate of Accounts and Treasuries are required to be refunded for conversion from NPS to OPS scheme, full stop. Mr. R. Pujal, Learned Counsel appearing for the Finance Department, has submitted that the department is finalizing the formulation of the procedure to be followed in recovering the amount deducted
Redepositing.
for redepositing the amount deducted as NPS contribution.
Yes,
List the matter again on.
can it be on my lord? Today, are they welcome? Can it be on my lord, 4th of June, my lord?
4th of June 2026, full stop. The Mr. S.K. Medi, Learned Counsel appearing for the Accountant General, shall also have his instructions as to why there is a delay in deduction of GPF contribution of the petitioners.
Refund of money.
Now, for refund, whom will they refund to? He is supposed to deduct it
He is supposed to. And
into your new account
New.
or into your reopened account.
GPF account.
He deducted it earlier.
Yes.
He did not deduct it for a certain period of time. Now he will tell us why he's not deducting it now.
No.
Why the deduction is not being taken place. Flood in with extra copies.
Is something, my lord, converting a writ petition into a civil division petition or vice versa, something like that. It is a procedure, my lord, technical system. I will come up with definite instructions.
Because all they need to do is get their money.
Yes. Nothing to be decided on merit. It is only, my lord, some technical issues. I will come up with concrete instructions. Finance and accounts and treasuries both have party respondents.
We had a hard time getting finances from our parents when we were kids. Now we are having a hard time getting finance
From the treasuries. Obliged.
It will be done, my lord. I'm so obliged.
Lordship, matter may be possible for the timing, Lordship. I think
There's no time being. We'll have it some other day. We'll have it on June. June. Kountu date dibo pare sokso. June ketia dibo pare. Mid-June did you?
first week of June, Lordship.
23rd to vacation again over no. Heavy take go. 16th of June. At the request of the Learned Counsel for the petitioner who is stated to be engaged in the matter. 23rd June. Same order. You 32. Yes, sir. What was the matter? Remind us.
This is the pensionary benefit, Lordship. Pensionary benefit.
Who is paying for the respondents? এখন কি সময় লৈ আহিলে হয় মা মিজোৰামৰ পৰা আহানো হেৰি অফিচ নথয় ভিতৰত দিয়ক What is your prayer? Yes, sir.
Lordship, only director of pension, Lordship, I am appearing, Lordship, other, the effective party is finance, Lordship, here in this case. Finance is the
Finance name is not shown. Item number 30.
30.
Finance material. Ah, you are there.
30.
30.
But I came up day before yesterday.
Ah,
A big apology, my lord. I was stuck up.
no difficulty. Just
Disciplinary
tell us.
proceeding. Here, what has happened, my lord? The petitioner has assailed, my lord, the inquiry report.
Hmm.
Now, we have filed our affidavit
Hmm.
to the extent, my lord, that the primary ground of the repetition is that, my lord, a substantial efflux of time has occurred, delay has occurred in culminating, my lord, the disciplinary proceedings and the inquiry report.
Hmm.
In our affidavit, we have taken a stand, my lord, that after the inquiry was done and the inquiry officer submitted his report, the petitioner's views were sought for, and the petitioner's view could not be, my lord, procured. Ultimately, the department has to go for newspaper publication to that extent,
Yes.
my lord, calling for, my lord, the views of the writ petitioner
Hmm.
in terms of the inquiry report. Finally, he has submitted his second show cause
Hmm.
in terms of the inquiry report.
Hmm.
Now, my lord, the department is to take a call. And my lord, there is a stay order passed by this honorable court, because of which, my lord, the departmental proceeding could not proceed further. And for taking a final order by the disciplinary authority views, my lord, it has to take the approval of the APSC. Everything is done and ready, but because of the interim order, because of this litigation, we could not proceed. So therefore, if this honorable court would be pleased to dispose of the writ petition, directing the finance department to complete the disciplinary.
There were 3 charges.
Yes.
2 charges not proved. Am I correct?
Therefore,
2 charges not proved. What is the third charge?
third charge is, my lord, it is there.
The one which was proved. Let us see the charge.
Yes. If lordship sees, my lord, the inquiry report.
Page 42.
Yes.
What you have stated is the correct. What you have stated is the correct position in law. There is no doubt about it.
Yeah.
But here is a question of delay in concluding the proceedings. Now, when the question of delay in concluding a proceeding is to be seen, this court needs to see what is the nature of the charges, whether anything substantial will come out in his service career, requiring him to be punished, or whether the delay itself has made the entire issue irrelevant now. Yes. If it becomes irrelevant, a man acquitted and found not guilty of at least 2 charges in the disciplinary proceeding also can be allowed to have some rest in his discipline, in his career. Is it?
Therefore,
yes. Now at page 42.
42, yes.
While the delinquent officer was serving as audit officer,
Yes.
he was remanded and sent to jail on charges of taking bribe. He was in police custody, which meant he was in jail custody for a period of over 10 days, which is unbecoming of a government servant. Now that cannot be a charge against him.
Yes.
Hopefully being arrested and staying in jail.
Well, this is the due process of law.
Now, it is also found that the delinquent officer had submitted casual leave applications covering the period of police custody from so-and-so to so-and-so,
Yes.
violating office procedure.
Yes.
conceding the facts to the superior authority violating Rule 3 of the Assam Civil Service Rules.
Yes,
Now, during that period, he was in custody.
yes.
In custody, if he is allowed to use a phone, he will use it. If he is allowed to write an application, he will write it. That is what he has done. Will the continuation of the proceedings after such a long time when he is now retired
Therefore,
have any relevance?
yes, that will have a relevance on his retirement benefits and all those things. It might quite so,
He
no, my
made
lord,
3 applications when he was in police custody.
no, my lord, apart from the
He
merit,
made 3 applications when he was in police custody, assuming to be true. Now that he has been found to be not guilty by the courts, now that he has already completed his service career, he will not go back to do anything more to the department.
definitely.
Does it have any relevance?
Therefore, let the disciplinary authority take a call. Let the
The call
disciplinary,
could not be taken for so long a time.
because of a
You could have done
interim
it.
order,
You could have done it without it. Without that, without giving him that he is absent, he is not answering. We find you guilty, finish it. Now is it the time where he can be troubled in his retirement benefits for 3 applications filed during his police custody?
Therefore, my lord, let the disciplinary authority take a call. It might quite so happen, and it is all probable that he will not be penalized. Matter ends there.
We do not know.
So therefore, and if
We do not know. Have you any judgment on this delay? Disciplinary proceeding delay, any judgment you have?
delay, my lord, I have also checked in, my lord, it depends from case to case, my lord. Supreme Court is clear on that. In factual situation, my lord, there can be some delay. But the vital part here is that, my lord,
Only on the ground of delay we are not inclined to.
But then if lordship interferes with the inquiry report.
No, not with the inquiry report. Inquiry report says nothing. Yes, we can even go back to the charge sheet. It is not here. Do you have the charge sheet and the records?
Charge sheet.
The record do you have? It is not here. Don't
It's
worry.
not here. Yes.
It is not here.
Even I do not have, my lord.
No, you will have the records of the.
Yes.
Can you call for the records of the case?
Absolutely. Absolutely. Why not, my lord?
Then when can we have it with the records?
Third of June, my lord. It will be Wednesday.
Today the matter was fixed for delivery of orders. The learned counsel for the petitioner has sought for an accommodation and is given an accommodation to produce relevant citations before this court. The learned Mr. Arbor Pujari, learned counsel appearing for the respondent, shall also ensure production of the records of the disciplinary proceeding before this court on the next date fixed. List again on the 3rd of June. This one. 3rd of June.
3rd of June. It will be Wednesday, my lord. I will.
3rd of June. Mr. S.K. Methi, learned counsel appears for the respond number?
7, accountant general.
You are for the accountant general.
My instructions even say, my lord, to pray before this honorable court for early disposal of this matter so that the disciplinary proceeding can be concluded. And I am putting it in black and white.
We would just like to see whether
absolutely
there is an option where a man can be allowed to.
But so far as my lord, timeline for this DP is concerned, there is no hard and fast.
No,
yes. The apex code is clear.
There has been a case, I often refer to it in different judgments, where a person had slapped someone, one of his colleagues, sometime in the year 1999.
My lord.
Lot of writ petitions, lot of this, that, Supreme Court back, remand back. 2018 or 19, finally the matter was disposed of by this court. And this court observed that one slap so many years ago No relevancy. All disciplinary proceedings cost.
Yes.
Don't do it again.
That's it, yes.
And he had suffered enough. 20
Yes.
years, 30 years without a job.
For one,
Nearing 30 years without a job.
absolutely.
For one slap.
For one slap.
Quite
All
correct,
relevance
but-
gone now.
Yes, yes, yes. Well,
So
I
maybe
take it,
these
yes.
3 applications, police custody, the mental pressure, the fear of losing a job, everything. One wrong statement made in the year 2000, I don't know, 7, 8, 9, something. Will it have relevance now?
Therefore, absolutely. Lordship is correct because
That is
Lordship
what we
will
will
be
just do.
examining the decision-making process. That's it.
Give him a censure,
Yes, yes.
finish it. Then APSC will also not be required. Censure, khatam. Yes.
I'm so obliged.
Lordship, can it be passed over for the day, my lord? My senior Askadas will be appearing in this case, Lordship.
At the request of the learned counsel for the petitioner, release this matter again on about July didiok.
Can it be after 3 weeks, my lord?
July diok olop pisole July heri manot diok.
Last part of July.
22nd of July, full stop. The matter is of 2018. Pleadings were exchange of pleadings were completed in the year 2000 on 9/3/2026. Full stop. Oh, what is the matter about?
This is regarding one of appointment of Gaungura, my lord, in the district of Dhubri.
Matter relates to the appointment of Gaungura. Full stop. Now he will actually become a Buddha. Forget a Gaungura.
Now, my lord, that
Then there was another selection process. People were appointed.
Lordship. South Salmora already been appointed, but
Ah.
Dhuburi, my lord, that selection process is not held. Lordship. So, my lord, that some
There is-
advertisement was given or published, Lordship, but due to some, my lord,
Litigation.
my lord, it was system.
On in July, we'll try to see that there is no further litigation.
Lordship.
Yes, next. 19.
May please, Lordship. This is again the my lord dismissal for service, Lordship. In this case, my lord, an SSB constable, Lordship, was Lord in duty, Lordship, sentry duty, Lordship. At my lord 23 o'clock, Lordship, 11 p.m. Lordship, night, Lordship, in a my lord very sensitive area, terrorist affected area, Lordship. My lord, suddenly someone, my lord, from jungle, my lord, fired a shot, my lord, towards him, Lordship. He retaliated, my lord, 27 round of my lord shots, Lordship.
1:27.
27 rounds, Lordship. He, that person, my lord, fled, Lordship. My lord, hearing the my lord accents, Lord, first, my lord, accents, my lord, his he was injured on his my lord palm, Lordship. Now, the proceeding, Lordship, this is my lord non-speaking.
Which is the dorsum side? Which is the dorsum side of the hand?
This side, Lordship.
Dorsum? Kindly find out which is the dorsum side.
This is palm. So, maybe the other side.
Kindly find out dorsum. What is dorsum?
Yes, sir.
Yes, tell us. Next.
Now, my lord, the proceeding, Lordship, was commenced on, my lord, that is at page 21. A summary force court proceeding was commenced, Lordship, page 21. Lordship. This is a, my lord, the commenced on 1/2/2018, Lordship. And charges, 4 charges were framed, Lordship.
Lordship, dorsum is here. It says back or upper part side of the hand. It's dorsum.
Dorsum?
Yes, upper side, this side.
Upper or oblique outer side.
Your
Back
case is
or
gone,
upper
sir.
side of the hand.
Your case is gone. Yes.
No, Lordship.
Now, the four charges, Lordship.
Just for a moment. Have you seen the medical report?
Well, the medical report, Lordship. This
No, the
alcohol
medical report which you have annexed.
Yes, I have an next, Lordship.
Ah.
That is at page 20, Lordship.
No, 18.
Sorry, I'm sorry.
Page 18, read
18,
page 18.
18, Lordship.
Read it.
My lord. Lower Assam Hospital Research Center, to whom it may concern, this is to certify that Mr. Manoj Janardhan of age 27 years, male from 15 DNSS Kazalga was admitted and treated for firearm injury of left hand. Two number
firearm
entry. On left palm and 2 number exit on left dorsum.
So exit is, just a minute. Exit is on the dorsum. Yes?
Yes, Lord.
The exit wound is here. Entry is here. You are on guard duty, holding the gun like this. How does the bullet go out from this side? Either you must be hands up.
As per his statement,
You must have been standing hands up.
His hand was up, Lordship.
There was one bullet fired. Someone fired one
that
bullet.
Statement was
One
Lordship.
bullet fired.
Yes, Lordship.
Before firing, he raised his hand.
But his statement is there.
It goes.
Now,
There was no shot. You put it on the muzzle, you pull the trigger. And in an intoxicated condition.
now the, my lord, alcohol test, Lordship. First charge was, my lord, alcohol test. My lord. Well, that was at next annexer page 20, Lordship. Negative, Lordship.
Where?
Page 20. Immediately after the incident, Lordship, he was admitted in, my lord, the hospital, Lordship, by the department, Lordship, departmental authority. My lord, alcoholic test was, my lord, conducted, my lord. In that test, my lord, his alcohol was found negative, Lordship.
Okay.
Now, this document was suppressed, my lord, not produced during the proceeding any time before the.
You also did not produce?
No, Lordship. My lord, I was kept mum, Lordship. Now, this document was not produced by the authority. This was suppressed by the commandant, Lordship. In that case, my lord, the hearing of the authority, my lord, disciplinary authority, and the my lord, judge of the SFC is the same person, Lordship.
Has to be.
My lord, now the charge, Lordship, kindly see charge number 1. This is 1 is alcohol, my lord. The accused number so and so, while deployed in Z-Koi of 15 Battalion SSB Kazalgaon is charged under Section 18C, being a sentry found in intoxicated condition while on duty. In that on so and so, Manoj Janardhan is found in intoxicated and fired 27 rounds of 5.56 mm inches ammunitions willfully from his personal weapon, that is 5.56 inches rifle, registration number so and so, at around 23 hours, Lordship, while he was on sentry duty at BOP Dhola of 15 BN SSB Kozalgaon without any reasonable threat and sustained himself bullet injury in his left hand palm over palmar suspect and thereby compromising the security of BOP pillow personnel, which is an act of gross indiscipline on his part, being a member of discipline force. Thus, he is committed offense under Section 18C of the SSB Act 2007. Next, Lordship, charge number 2. So and so of FCOI of 15 Battalion Kazalgaon is charged under Section 27C.
Yes, sir. How is this charge of intoxication proved? What is the basis for saying that he was intoxicated?
Doctor, that has been supported by
The deposition of the witnesses, Lord.
Saying what?
Lordship.
You have any judgments with you, sir? Regarding consumption of liquor?
Yes, Lord.
Any judgments?
Yes, Lordship. A judgment is that this honorable court judgment, Lord, is
Please.
Nobo Kumar, Nobokanto Kolita, Lordship.
Ah,
That was decided by Honorable Justice Ujjwal Bhuya, Lordship.
it is on intoxication.
Alcoholic, my lord. It is. Please admit like that. Systematically.
Lordship, page 29, Lord.
Anybody saw him drinking?
Lordship, page 29, they said, well, a PW2 statement, Lordship.
Strong smell of liquor.
Lordship.
And? And
he was not cross-examined by the petitioner.
Need not be.
Yeah.
Then, Lordship,
My lord,
PW3 also.
Lordship. Paragraph 56, Lordship.
Paragraph, just let us see if that can be enough.
Lordship, PW3 also stated, page 32.
Paragraph? That
Page
he got a
32.
strong
He
smell
had
of
consumed liquor and might have fired himself in his left hand.
He consumed liquor. We saw him consuming liquor, no.
Even if, Lordship, this alcohol part is whether I'll be on the other part, Lordship.
Which part?
That injury, Lordship, self-inflicted injury and causing loss to
Because we said so. The dorsal part we said.
Property of government, Lordship.
He might have been afraid. He might have.
Lordship, I will produce one judgment of Supreme Court.
Yeah.
Similar, exactly similar case, Lordship.
56, Lordship.
56.
55, 56, my lord, conjoined Lordship. Married Lordship.
So alcohol is gone.
My lord. That is main charge, Lord.
There is one judgment, Justice N. Koteshwar Singh, Manipur High Court.
Not taken that far.
Manipur High Court, find out.
You know, Manipur High Court.
Find out. We are bound by that judgment. Find out. One by the Supreme Court.
Lord.
No smelling business.
Lordship, in this case also terrorist attack was same plea was taken. Paragraph 29, Lordship.
No, was that? No.
2021 11 SCC, page 321.
2021 11 SCC, page 321.
Here also plea was taken the terrorist attack command, Lordship. Not a single bullet was recovered. Nobody said some terrorist fire from the other side.
So now, but this man has got a bullet hole inside him.
Self-inflicted.
Your issue is that it is self-inflicted. So did you test the bullet and the gun? What test is it called? Ballistic test.
Ballistic test.
Done.
That
report is there. It is not there.
But injury is there.
Injury is there. It may not be a by a bullet. We don't know.
No, there is empty cartridges was recovered.
27 were recovered.
He fired 27 rounds and not a bullet from other side.
We don't know.
Not a single witness stated that bullet came from the other side.
He was alone.
Lordship?
He was alone.
Lordship.
Everybody has said we were sleeping.
Lordship.
So who will say who fired?
The empty cartridges ought to be there.
Huh?
Empty cartridges ought to be there.
27 were fired. 28. You say 28. One at his end.
Such can be excused, Lordship. Can be condoned.
Intoxication is gone. Ballistic report not there. You want to do it again, do it again. But on this evidence,
Lordship, can you get paragraph 29 of this judgment, Lordship?
$29. Hmm.
The sixth line, Lordship, from his further stand is that it was a terrorist attack and terrorists have fired on the cab. None of the departmental witnesses have been even seen suggested about any terrorist attack or that the writ petitioner out of the camp. Constable D.K. Misra had immobilized the writ petitioner, whereas all other witnesses have seen the writ petitioner being immobilized and being removed to quarter guard. That soldiers had taken the self-loading rifle of the writ in their position. Therefore, the allegation that the charge sheet dated so and so that the writ petitioner has fired from the official weapon is a reliable finding written by the department on the basis of evidence placed before them. It is not a case of no evidence, which alone would warrant interference by the High Court in exercise of power of judicial review. It is not the case of writ petitioner that there was any infraction of any rule or regulation or the violation of the principle of natural justice. The best available evidence has been produced by the appellants in the course of their inquiry conducted of the long lapse of time. So whatever the best evidence we have produced, Lordship.
What is the charge here? How many charges?
Four charges, Lordship.
So that is what facts are different.
No, here is that's
Facts are different.
he fired
Charge
upon,
is
he fired upon,
charge is misused his service rifle and ammunition without having the order of competent officer. That was the article of charge. In your case, the article of charge is that he was drunk. He used his own gun to fire at himself.
he voluntarily caused hurt.
To himself.
Lordship, offense in respect to government property. The third one.
Intentionally destroyed by firing 27 rounds.
Yes.
From his personal weapon on so-and-so.
So what justification he has given?
What have you given? What is your justification?
His justification was that some extremists fired upon him, so he fired. But nobody supported his case, Lordship.
Guard duty, he would be alone.
We take it as an adjustment.
Yes, lack of evidence. And what more?
My lord, that's lack of, my lord, witnesses, Lordship. These all the witnesses, my lord, are copy paste, Lordship.
Okay.
My lord,
and
PW2, Lordship. PW2, my lord, PW2, PW6, my lord, PW10, all says, Lordship, all say, my lord, fire was towards jungle. Now, no, my lord. That was, my lord. On the other hand, PW10 statement of PW10 statement, no liquor, my lord, nothing was, Lordship. His behavior was normal, Lordship. My lord, had it been, my lord,
liquor part gone.
yes, Lordship.
Your firing part.
Firing mark that was towards jungle, Lordship. And during statement, Lordship, the witness said, my lord, before witness, Lordship, he stated, "Usne mara, may be mara." This is the, my lord, language. So,
any procedural lapse?
my lord, procedural, my lord, I have not gone through, Lordship, now, because, my lord, I have found nothing, Lordship. And as regards the, my lord, perversity, Lordship, that is there.
What is the perversity?
Perversity, my lord, kindly see the evidence, lordship. Evidence starts from page 24,
Ashok Kumar, no,
page 20.
AK Swine. AK Swine.
AK Swine's case.
Is an AK. Drunk firing, single round. Justice N. Chaudhary. Itanagar bench.
Okay. কি নাম part?
CRPF.
কি নাম বলি বলো?
Single shot fired drunk.
Justice N. Chaudhary's judgment.
Justice N. Chaudhary's judgment on CRPF. Dismissed, writ appeal dismissed by the division bench. Yes.
My lord, PW1 lordship. He is lordship Gopal Sakma. May I read lordship?
So evidence, we will not go through the entire evidence. What we wanted to see was whether intoxication is proved, intoxication is not proved.
Interested.
And firing from your gun is proved.
That is, my lord, I agree.
And there is no,
fired loss because of that lordship.
there is no evidence to show that there was any such incident of any terrorist attack or anything, or any shots being fired from the other side.
Because I was alone, man,
Have
nobody
you
had
gone
seen
through
my
this? Have you gone through this judgment of Union of India versus Dalbir Singh?
No lordship.
No.
No lordship. I've taken some
You have the
judgments.
citation now?
I have some, you lordship. One judgment, Nobo,
Do you?
Shina lordship.
Huh?
One judgment, Nobo, Shina, my lord, the plea. As regards, my lord, the what point loss?
What?
My lord, you know, what point first? I have taken some judgments and other points, fairness,
I
lordship.
have asked whether you have gone through this Union of India versus Dalbir Singh, which has been
No
produced
lordship,
by
no.
2021 11 SCC 321. Please take the citation.
2020 11 HCC page, I lordship, sorry, page number
321.
321. That is one. Okay.
Any more grounds?
My lord, that is the, my lord, my lord, the charges have not been proved by evidence, lordship.
Leave.
So far as lordship, there's alcohol test report which we have submitted in this petition that was never produced during the course of inquiry, during the record of evidence, at no point of time.
That was a record with you.
No, I have my records. No, he went off he went off his own.
No,
that hospital.
The hospital, he had been taken to the MI room.
This hospital.
From the MI room,
He can annex all.
He'll be taken to the hospital.
He has submitted all the papers.
Listen to us, sir. Some procedure we know inside what happens. He'll be taken to the MI room. From the MI room, the entire thing will go with a convoy to the hospital. Everything will then be kept by the authorities, including the discharge slip.
Lordship.
From the hospital, he'll be brought back to your own MI room, and thereafter he'll be given back everything if he asks.
That record I have, Lordship.
Which one?
There is no one. Is the DP proceedings entire record?
No, not the DP
original.
proceeding. So that record,
all medical papers are here.
that medical paper,
all medical papers are
particular
here.
medical paper, where did you get it?
My lord, it was given, lordship.
Where did you get it?
Let him produce.
My lord,
True.
Original.
You must have certified it, true copy.
it was taken while discharging, it was given, lordship.
To you.
My lord.
You have given certified true copy.
Okay, next, sir, my lord.
Where is the original?
Certificate issued by the hospital.
Page 20, I am telling you.
20, lordship.
Tell us where is the original. What's the original?
Yeah, Lordship.
And it is Lal Path Labs, Lordship. Lal Path
Yeah,
Labs.
discharge certificate, Lordship. It was
Of the
given
same day,
xerox
sir.
copy, Lordship.
Of the same day.
Same day.
So he was still in your custody when he went for this alcohol test.
But-
And he was released on 2/11/2017.
Not true.
And this is a blood test for alcohol, so correctly done.
Maybe. Maybe if he has that.
The charge that he was intoxicated,
The original is not.
but the charge that he fired.
We don't
Without
have any
appropriate-
medical papers to support that, but
I'm sorry, Lord.
all
Original is.
oral
And
statement.
from where this CTC has come? Certified true copy?
My lord, then this was
Heard
my lord.
Mr. So-and-so
Case was
counsel
filed by
appeared
my
for the
lord,
petitioner.
filed under.
Also heard Mr. B. Chakraborty, learned counsel. Huh?
My lord, case was filed by some other advocate, Lordship. Subsequently,
Also
it
heard
was-
Mr. B. Chakraborty, learned CGC, appearing for all the respondents. Full stop. The challenge in the present petition is to the order dated
This is order dated, Lordship. Lord 16,
23 to 2018,
Lordship.
by which the petitioner stood dismissed from his service. Full stop. The petitioner has also challenged the order dated 22/4/2018, by which, no, 22/4, no, huh? 16/7/2018, by which the departmental appeal filed by the petitioner had been dismissed. Full stop. The learned counsel for the petitioner has drawn attention of this spot. Has submitted that the petitioner was serving as a constable general duty with the Sasastra Sima Ball and was posted at the 15th Battalion at the time of the incident. Full stop. The petitioner was on what duty?
Sentry duty, Lordship.
Was on sentry duty on the 16/10/2017, when around 27 rounds of when 27 rounds had been fired from his automatic from his personal weapon, that is a 5.56 inches rifle, at about 2300 hours. Full stop. The petitioner received a bullet injury on his palm, which according to the medical certificate showed that the exit wound was on the left dorsum of the hand and a lacerated injury medial aspect of the left palm. Full stop. The petitioner was admitted to the Lower Assam Hospital and Research Center, Chapaguri Road, Bongaigaon, by the authorities of the SSB, where he remained on 17/10/2017, where he remained under treatment till 2/11/2017, when he was released. Full stop. The learned counsel for the petitioner has submitted that the blood test conducted on the petitioner on the blood sample collected on 17/10/2017 showed a negative on the alcohol within bracket ethanol screen test, and therefore on a full stop. Okay. On 1/2/2018, the commandant of 15 Battalion SSB had convened a summary force court under the provisions of the SSB Act 2007 and SSB Rules 2009 for the trial of the petitioner. Full stop. The charges level against the petitioner are as follows. Page 22 jabo. Charge 1. Charge sheet likha ase. A pra apni maribo. Page 23, 23. Page 23. Ekdom last loke ma aako pencil diye likhi disu. Full stop. Pursuant to the trial held, comma, where as many as how many? How
11
many witnesses, sir?
11 witnesses.
11 witnesses had been produced on behalf of the disciplinary authority, comma. The disciplinary authority found the petitioner guilty of how many charges?
All charges, Lordship, 4 charges.
Guilty on all counts. Full stop. How many witnesses did you produce?
No, I did not.
Did you examine yourself?
My lord, no, Lordship. My lord, a statement, my lord, was submitted, Lordship. My lord, that was on record, Lordship. FS 63.
During the
58.
during the trial,
58,
the
Lord.
petitioner had submitted a written statement which was also taken on record.
Lordship.
Huh?
No findings in this regard, Lordship.
Huh?
It does not place in finding, Lordship.
It does not?
It does not discussed in the findings, Lordship.
We'll stop. I'm just recording the facts now.
Lordship.
We'll stop. The petitioner was thereafter sentenced by the court to be dismissed from service under provisions of section 51. 51 within bracket 1 within bracket C of the SSB Act 2007. The order promulgating the sentence of dismissal on the petitioner was issued on 23/2/2018. Full stop. The petitioner thereafter preferred an appeal to the Deputy Inspector General, comma, what is SHQ? Sector Headquarters SSB Bongaigaon on 9/3/2018, whereas and by the letter dated 6/4/2018, the petitioner was informed that the appeal would lie to the Inspector General, comma, Frontier Headquarters SSB at Gauhati. Full stop. Accordingly, the petitioner filed an appeal. Dated. When did you find the appeal? (22/4/2018) to the Inspector General Frontier Headquarters SSB, which came to be rejected on 16th of July 2018. The learned counsel for the petitioner has submitted that a perusal of the statements of the evidence led by the 11 prosecution witness would show that none of the witnesses had been able to substantiate the allegation of intoxication against the petitioner. Full stop. The learned counsel has submitted that as per the evidence of the witnesses, comma, the petitioner on being approached after the firing incident had told everybody that he had been shot, oblique, he he had fired and he was also fired at, etc., comma, thereby indicating that the petitioner had in fact been engaged in a firing with unknown miscreants, full stop. The learned counsel for the petitioner has submitted that there is no evidence to the effect that the petitioner had fired upon himself or had misused the weapons and ammunitions issued to him for purposes of his services, full stop. What else? What else is to be recorded? Tell us.
Evidence lordship of PW 10 lordship. Page 55. Statement.
Page 50?
Page 55. During his statement lordship, my lord, some questions were put lordship.
By whom?
My lord, by court lordship. See lordship, kindly see lordship. My lord,
the learned counsel for the petitioner has submitted that the prosecution witness number 10 has, during his questioning by the court, submitted that the behavior of the petitioner was normal.
Normal lordship.
And the next question also, Lord, may be seen, Lord.
Now, my lord, while cross-examination PW2 lordship, sorry,
The learned
PW1.
counsel for the petitioner has referred to the cross-examination of the PW number 2.
Sorry, PW1 lordship, only one. That
PW1.
Lordship. He was cross-examined lordship at page 28, no.
Page 20?
PW1. Page 24 lordship.
Page 24?
Lordship.
Page 24, yes.
My lord, herein, my lord, have you seen me firing by my personal weapon in
Page
the air
24?
or my... No, I have not seen. Page 26, lordship.
26, yes.
My lord, this witness was, my lord, cross-examined lordship.
Hmm.
My lord, witness, question number 3. My lord, this, have you seen me firing by my personal weapon in the air or in my left hand palm? Answer, witness, I have not seen.
The learned counsel for the petitioner has drawn attention of this court to the cross-examination of the PW number 1, where the PW number 1 has stated that he did not see the petitioner firing by his personal weapon in the air or on his left palm.
No, sir.
Full stop. Next.
As regards other, my lord, why I did not, my lord, cross-examine lordship. I was, my lord, 310 lordship. I have stated in the, my lord, reply affidavit, my lord, additional affidavit lordship. My lord, the commanding officer lordship threatened me to keep me mum lordship. Otherwise, I was threatened to send by rapping with my lord, Tironga lordship. I have stated this. That is why, my lord, I did not cross-examine, my lord. On the other, every witness evidence was were recorded in English lordship. I was not, I don't know, and I don't understand the language English. My lord, it's an every evidence lordship.
Yes,
Statement defense lordship.
What has been done in the appeal, Lordship, page
No.
83.
Tell us from your records.
83 page.
Page 83.
83, Lordship. On English, paragraph 4, Lordship.
On the other hand, my lord, my statement.
Just a minute, we are going one by one, sir. We have to understand.
I'm sorry, lord.
That much.
Paragraph 4, Lordship.
Paragraph
4, page 83. On being arraigned by the summary force court, the accused pleaded guilty to first and third charge and pleaded not guilty to the second and fourth charge. Thereafter, the trial proceeded to on plea of not guilty. First, in accordance with the SSB rule so-and-so, charge of the charge sheet, and the court has examined 11 prosecution witnesses and statement. All the PWs have been read over to the accused in the language he understands, that is Hindi, to comply to the provision of SSB Rule 2092. Further, the court has given opportunity to the accused to cross-examine witness PWs, which is availed by the accused. So it was explained in Hindi, Lordship.
That will be one difficulty again. Yes, the learned counsel for the petitioner has submitted that the entire proceedings have been conducted in English, a language with which the petitioner was not conversant with.
Lordship.
And he has given friend of accused
Therefore, he was prejudiced, full stop. The learned counsel for the petitioner has also submitted that he was not allowed to cross-examine the witnesses
Lordship.
under threat of being, under
on the
threat, comma, where he was asked, under threat,
Only
under
my
threat from the disciplinary authority, full stop, from the, under threat from the court, full stop. Where is that ground in your appeal?
My lord, paragraph, my lord, paragraph.
In your appeal, did you take that
Yes,
ground?
I have stated in the, my lord, in appeal, my lord, a statement, lordship, a letter was submitted, lordship, subsequently. I have stated, lordship. Kindly see, my lord, that page
80.
lordship.
Appeal is at page 71, Lordship.
Huh?
Appeal is at
Page
page
63.
71.
No, at page 80, he has taken the stand that I was not allowed to
Page
cross-examine
63, lordship.
at any point of time. What did you write?
Page 63, lordship, kindly see, lordship, I have stated, my lord.
Page?
Letter was given to the, my lord,
Page?
63, lordship. Annexure G, Roman 2, lordship. This was written to my lord as Inspector General, lordship. My lord, my appeal was not decided, then my lord, I posted this letter, lordship, and this is my, I have stated, lordship, that it is not voluntary, lordship.
Mr. Learned Counsel, appealing for the petitioner has submitted that the medical certificate issued by the Lower Assam, issued by the Lal Path Lab on the day on which the incident, unfortunate incident had also taken place, comma, certifying the absence of alcohol in the blood of the petitioner had not been produced before the, not been produced during the disciplinary proceeding and in such, and therefore also the disciplinary proceeding against the petitioner appears to be biased.
Lordship.
Anything more?
That is lordship. On the other hand, other points, lordship.
The learned counsel for the petitioner has placed reliance on the judgment of this court in Nobakanta Kulita versus Union of India and others, reported in 2016 4 GLT 1060, comma, to submit, to buttress his contention that the allegation of the petitioner being in an intoxicated state had to be proved by the during the department inquiry by referring to medical examination of the petitioner, full stop, merely on the basis of presumption and suspicion. It could not have been said that the charge of the petitioner for being in an intoxicated state while reporting for duty would stand proof, full stop. This court had held that mere smell of alcohol, unsteady gait, and incoherence in speech would not be sufficient to hold that the petitioner was in an intoxicated state of mind at the time of the alleged incident, full stop. Yes.
My lord, my lord, the service record has been, my lord, stated in paragraph 65, lordship. My lord, everything is good, lordship. My lord, the record is, my lord, 12 months service record is, my lord, noted, lordship. My lord, page 65. My lord, punishment nil, cash reward nil, commendation nil.
The learned counsel for the petitioner has submitted that the service record of the petitioner produced during the proceedings before the sentence in the trial would reflect that the petitioner had never suffered any punishment prior to this incident, and irrespective of the trial, his general character had been satisfactory. Full stop.
My lord, in such a, my lord, case, lordship, I have a family, I have served the, my lord, the nation, my lord, on the very day. My lord, may it be, my lord, misunderstanding of facts, lordship. My lord, even if, my lord, I don't admit lordship, even if it is probe lordship, then, my lord, night, my lord, 11 am, this is sensitive area, lordship. My lord, this is sensitive area. My lord, may it be misunderstanding of fact, lordship. In such a case, my lord, the dismissal from service, my lord, when the liquor, my lord, in my humble submission, the intoxication is not probe, lordship. And no evidence, my lord, causant evidence is not, nobody has seen the inside, and I have fired, my lord, without any reason, lordship. Everything is, my lord, on conjecture, lordship. My lord, copy paste like the evidence, lordship. Now, in such a case, lordship, the punishment so, my lord, imposed, my lord, the dismissal from service is, my lord, very harsh, my lord. Many other punishments are there, lordship, my lord. Even if it is you feel lordship, that it is probe lordship.
The learned counsel for the petitioner has submitted that assuming but not admitting that the incident of firing had taken place from the service weapon of the petitioner, the learned, the disciplinary authority had failed to appreciate the fact that the same could have arisen out of a mistake of fact.
My lord, even if it is a mistake of maybe, my lord.
And in such circumstances, the punishment of dismissal from service
Very
would be very harsh upon the petitioner. Full stop. The learned counsel has submitted that the disciplinary authority had failed to take into note that the petitioner had a family to take care of. And yes,
lordship,
the punishment imposed upon him is disproportionate to the
lordship. So the
allegations leveled against him.
My lord, the PW6, my lord, has stated no notice, my lord, consumption, liquor, nothing, and only towards jungle, lordship. No other way, my lord, he fired, lordship. This is the evidence, lordship.
Yes, further submitted that the only evidence available on record is that the petitioner had fired toward the jungle and not in
Caused
any
any
other
harm
direction
to
or to cause harm to any person,
any property, lordship.
any person or property, full stop. Your submissions. The Mr. B. Chakraborty Learned Counsel appearing for the respondents has submitted that what do we say? That the evidence led by that the petitioner has not alleged any procedural flaw in the departmental proceedings conducted against him, and as such, the impugned orders passed by the disciplinary authority or the appellate authority do not require any interference of this court, full stop. The learned counsel has further submitted that it would be evident on record that the witnesses have mostly indicated towards the intoxication of the petitioner on that fateful night when they had met him immediately after the incident, full stop. The learned counsel for the respondent has further submitted that there is no denial of the fact that the petitioner had fired 27 rounds from his weapon on the night intervening 16/10/2018 and 16/10/2017.
18 laws.
16/10/2017 and 18/10/2017.
No, incident occurred on
16/10/2017 and 17/10/2017. The learned counsel for the respondent has submitted that the doctor who was examined, the doctor who had given first aid to the petitioner immediately upon him being brought after receiving the gunshot injury, had also testified that the petitioner was reeking of alcohol. Full stop. The learned counsel for the respondent has submitted that the intoxication of the petitioner being one of the charges, comma, the other charges were more grave in nature, in which the petitioner had, without provocation, while performing the duty of a sentry, had fired 27 rounds from his personal weapon and intentionally and voluntarily caused hurt to himself, and thus had committed offences under section 18C, 27C, 33E, and section 43 of the SSP Act 2007. The learned counsel for Mr. Chakraborty has placed reliance on the judgment of the apex court in Union of India and others versus Dalbir Singh, reported in 2021, 11 SCC 321, where he has referred to paragraph 29, which is reproduced herein below for ease of reference. Full stop. You have the disciplinary proceeding records?
Lordship.
You have the records of the disciplinary
Lordship.
proceeding? Kindly find out if he was asked whether he is conversant with Hindi and whether he would require any other language to be used. Can you find that out?
Lordship.
Stop. We have heard the learned counsel appearing for the parties, and we have also perused the records which have been placed before us. Full stop. At the first glance, this court notices that in the absence of the present matter challenges a disciplinary proceeding along with the orders passed by the disciplinary authority and the appellate authority. Full stop. The apex court in the case of blank has laid down that the powers to be utilized, the powers under the jurisdiction under Article 226 of the writ court could be exercised in the matter of a disciplinary proceeding would be limited to the following conditions: 1, 2, 3, 4, 5. The learned counsel for the petitioner, no, the writ petition does not disclose any of the challenges which have been held to be substantial for exercise of powers of Article 226 of the Constitution of India. The learned counsel for the petitioner has not pointed out any such flaw in the any such procedural flaw in the departmental proceedings which would require this court to exercise the powers under Article 226 of the Constitution of India. Be that as it may, since the allegation has been, since it has been pleaded before this court that the petitioner had suffered injustice since the evidence laid before the disciplinary authority had not received the proper attention of the disciplinary authority, and further, when the and further that the petitioner had also suffered prejudice when he was not allowed to have an effective defense, this court deemed it fit to refer to the records of the disciplinary proceedings to satisfy itself regarding the correctness of the assertions made. Full stop. Yes.
Lordship, at the end of every cross-examination, Lordship, it has been stated, the above statement has been read over to me in the language Hindi. I understand, admit and sign it correct.
And that is also written in English.
Lordship.
मुझे हिंदी में समझाया गया, समझ में आया. Then he could have signed it.
It is
the explanation is also in English.
In the language I understand. Hindi.
You are saying it in English. What
Lordship,
doesn't
that
know
is
what
he
he's
said
saying?
but it has been explained to him in Hindi. Lordship, finding at the
When
end
he
of
does not-
every witnesses.
When he does not understand English, writing down that sentence at the end of the page, is it helping him in any manner?
He's been given friend of accused also, Lordship.
Who he says does not make any effort to defend me. In his appeal, he says, no effort to defend me, nothing done.
And he admits the charges. He said, I am under pressure. That is
Where?
He gave statement, Lordship.
Where?
Lordship.
Is it
Page
written statement?
63. Page 63.
Did you do that?
It is further submitted that due to pressure of the summary force code, I admitted charge level at serial number 1 and 3.
ईमान को मैं और मेरे ड्यूटी पिछू आसपास अपनी टोपी निकालकर सिर के ऊपर हाथ घुमा रहा था। उसी दौरान जंगल की तरफ से एक राउंड फायर होकर मेरे बाएं हाथ को लगा। उसी दौरान देवनाथ का संतरी था, उसने होटर बजाया और मैंने अपना पर्सनल हथियार राइफल ईमान किया और मैंने देखा कि जंगल की तरफ से एक आदमी जो काला टी शर्ट पहन रखा था उसी के पैर के निशाना बनाकर एक राउंड फायर किया शुरू किया, लेकिन मुझे डर था कि राइफल ग्रेनेड फायर करके मैंने जिससे कंपनी के जवान मेरे को मेरे नुकसान पहुंचा सकते हैं, तो मैंने अपनी जगह बदल कर पुलिंग ट्रेंच में चला गया तथा एक राउंड फायर करता रहा। उसी दौरान मेरा हथियार रुक गया और मैंने मैगजीन बदलने और फायर करता रहा। मेरा फायर खत्म होने के बाद लगभग 4-5 मिनट के बाद स्वयं बिकने लगा तो हुआ थोड़ा सुधार हुआ। उपचार के बाद गुवाहाटी जीएमसी अतः महोदय कहाँ where does it say that there is a pressure?
63, page 63. Page 63.
This is the appeal.
Yes, Lordship. The second paragraph.
I had admitted the charge leveled at serial number 1 and 3. Now, where is that?
It is further submitted that due
that will
to
be there in
pressure.
the record. I have admitted.
Lordship.
That will be there in the record, some sentence.
Lordship.
এটা কাম করো। এইটো অৰ্ডাৰটো এইখিনি আছে নহয়, এইখিনি টাইপ মাৰি উলিয়াই দিব হা। এইখিনি উলিয়াই থব। We will not have the time today to complete it. What we will do is we will say it is heard in part. We will fix it. That date দিয়কচোন। জুনৰ second week দি দিওঁ। Sorry. 11th of June. We'll see. Heard Mr. Swensel and a counsel appearing for the petition. Also heard Mr. B. Chakraborty. You give me the records also. I'll go. Mr. B. Chakraborty and a counsel appearing for the respondents. Heard in part. List again on the June, no? 11th of June.
Lordship, the proceeding on plea.
No, you flag mark the whole of it and you please give it to the court master. Will have it, keep it tight. The records produced by the learned CGSE is kept on record. Is retained in record till disposal of the case. You kindly flag mark the important parts. See, we may find you not intoxicated, but the other part we are not convinced.
Other part is related with the one Lordship. Other part is related, my lord, with my lord.
If you have fired 27 rounds without being intoxicated, that is more dangerous. If you are intoxicated, it would have been some mercy.
Possible like that.
27 rounds without
But to
being
save others, Lordship.
Huh?
To save others, Lordship.
To save others. Yes.
Some time, because we have missed.
Why?
That file is untraceable, Lordship, so we need some.
2019.
Yes, Lordship.
Okay. Give her a complete set. PDF.
I will start today.
Lordship, first week of June.
June we are overburdened. We'll have it in July beginning. Huh? Miss so-and-so on a council appearing for the petition for Mr. R.K.D. Chaudhary, Learned Senior Counsel and Assistant SGI or DSGI.
DYSJ.
The DSGI has submitted that the records are not traceable. Stop. The Learned Counsel for the petitioner has agreed to supply a fresh copy of the records of the writ petition along with the affidavit in opposition and other documents available to the to Miss So-and-so Learned Counsel. Full stop within a period of 1 week from today. Accordingly, list this matter again in July data due. For hearing, the matter is of 2019 and relates to a disciplinary proceeding.
Yes.
Dismissal from service.
Yes.
Compulsory
Compulsory
retirement.
retirement. Initially removed from service, then
Compulsory relates to compulsory retirement of the petitioner from his services. Full stop. The respondent shall have the records ready for perusal on the next date of listing. 28 July.
20.
Yeah.
Obliged.
I am appearing in 24, my lord.
May I please, Lordship, this may be taken after some time. My senior is on the way, Lordship. Just few minutes, Lordship.
Even in the 23, Mr. Itzke Das, he is appearing, my lord. I think he also has some difficulty. He told me there is a division bench and he has a matter before the division bench.
This is relating to what?
My lord, disciplinary
Something
proceeding
urgent or
leading
can
to
be taken up
dismissal,
in the month? Huh?
leading to dismissal from service, my lord.
Dismissed when?
My lord.
Submitted. Appellate order was communicated in 2020.
2020, my lord.
We'll have it in July on the reopening.
After vacation, also.
Immediately after vacation.
Any date may be fixed.
The dates are a little adjustable then.
Okay.
Prior to vacations, around 2 weeks you can take, we'll go for motions and all.
June, will it be
Hearing
possible
no
in the month of June, my lord?
June.
Any day then June.
18 June পারি নেকি? We'll try 18th. We will try for 18th. I don't have that computer is not working. If 18th is overburdened, we'll keep it for 23rd.
May it be kept on 23rd, my lord. 23rd.
23rd. Okay, 23rd. We'll keep it on 23rd.
23rd, no small difficulty between my some.
And it has to be 18th. 18th.
18, my lord, some difficulty. Another matter is fixed.
16.
Because my lord, two matters are taken together out of the means proceedings are different. My lord, yeah, quasi-judicial proceedings. I don't know why it has been taken, my lord. There is some order in passed in item 23, I think. Actually, during a period of time, some misappropriations took place in a particular branch of the SBI. And lock, stock, and barrel, my lord, some of the branch managers were put to disciplinary proceeding culminating into dismissal from service. Now, my lord, my challenge against the order of dismissal will definitely be different from what is being challenged in item 23.
But there is one
Can it be on
common thread,
21st,
Madam.
Lordship?
When the procedure followed is the same.
No, procedure not.
No. If the procedure, I'm not talking about the proceedings. I'm
Lordship.
talking about the procedure. This is how it went on. Every man is, in every department, a certain routine is followed. First you give this document, then you call him, then you do this, then you do this, and then you finish him. If that routine is wrong for one, and if it is commonly followed for others also, Everybody benefits.
Okay.
In the Central Reserve Police Force, we did not have a presenting officer. Around 70 to 80 writ petitions were allowed because there was no presenting officer. On one ground,
On one go.
although different proceedings. Maybe for that purpose.
Maybe, but I would like to make a prayer that I may be heard separately.
We'll have, each discipline proceeding, each matter will be heard unless it is a joint
Independently.
proceeding.
Perfect.
Unless it is a joint proceeding.
No, not
we'll hear
contempt.
joint proceeding.
Not a joint proceeding.
So 16th of June. Ase jaga?
16th of June.
16th of June
16th
will
of
make attempt at the request of the learned counsel for the petitioners. At the joint request of the parties, list this matter again on
My lord,
16th of June.
excuse me, my lord. Yesterday, one matter was already fixed on 16th, related to the bank proceedings only. Like, can it be on 21st, my lord, if court permits? 21st, my lord.
21st of June.
Yes, my lord.
21st of June on a Sunday, we can all sit down and do matters.
No, my lord, on 21st. I'm sorry, 23rd, my lord.
23rd, my difficult, I am extremely
23rd
sorry,
is
my lord.
25th, one day before vacation. Ultimately, it is after vacation.
My lord, might be after
Ultimately, it will go after vacation. Then, my lord, let it come up after vacation.
Let it
Let
come
it
up
come
on
after
the
vacation.
21st of July.
21st of July.
21st of July for hearing.
Lordship.
Possible.
The respondents shall keep available the records of
Yes,
the
my lord. Reports have been received.
You give your names in writing.
Obligation.
Yes.
We have challenged the selection procedure, my lord.
Of
Recruitment, my lord. Selection for the post of peon cum chowkidar, my lord, in the Department of Public Information.
you got 52 out of 50.
50.
Good. He got 52 out of 50. Huh?
Still not selected, man.
Still not selected. Others got more than you. Who appears for the other side?
Senior counsel, my lord, T. Chutia. The other occasion, my lord, asked us to prepare a written argument, my lord.
Have that?
Yes, I have submitted, my lord.
Yes. But then in his absence, can we take
Yes,
it up?
yes, that is.
Mr. P.K. Munil, learned counsel appears for the petitioner and has submitted that the written argument on behalf of the petitioner has been submitted. None appears for the respondent today. In the interest of justice, list this matter again on. We'll have it immediately on the reopening.
Date will fix.
We'll have a date. Motion date is due. 14 July, 17th of July. This was for hearing.
Hearing.
But then on a hearing date, you are appearing for whom, madam? Sorry, is here. Can we take up this matter, sir, today?
Lordships.
None appears to go. This is and senior counsel.
Next week, Lordship.
How does he get 52 out of 50?
PP.
He alleges that he got 52 marks out of 50 marks. How is that possible?
I will explain.
In their reply, they have said that it was a printing mistake in the question paper, my lord.
There were more marks in the question paper.
No,
Not question paper, my lord.
questions, my lord. Each question carried 2 marks, so it was 100. But there was a printing mistake in the question paper which says each question carries 1 mark. But it carried. That is how the whole process had been gone through.
Petitioners, my lord, 4 names is same name.
Sompokolta, four names appeared, and they applied as a Sompokolita and sometimes Sompok Atpuria. So they said, my lord, one of the Sompokolita got 52. That was mistakenly given to him. That is his case.
At 4-5, how he got 52 out of 50 and how many names he has.
That is the my lord.
Diok June or 16th of June.
15th of June.
16,
16th, my lord.
16th of June. At the request of the
Obliged,
council for the parties. এটা আছে।
May I please your lords?
Yes, sir.
Lordship, this matter relates to enhancement of grade pay of the members of the Petitioners Association.
Oh.
That is the prayer before this honorable court, your lordship, in the writ petition.
Can it be done in the next 20-25 minutes? Huh? Enhancement of
Lordship,
grade.
Mr. Gogoi is on Lex Melody on in court number in the special division bench. So the matter, my lord, can be taken up on some other day, my lord.
Lordship, only difficulty is this, your lordship. In the meanwhile, your lordship, next pay commission has also been constituted.
If you win this case,
Lordship,
it will be fixed, it will be correctly fixed. And then in the next pay commission, you will be correctly refixed.
Lordship, no, your lordship, that's not my submission. Pay commission has already been constituted, your lord. So before that, your lordship, the commission goes into all the issues, your lordship. I want this matter to be finished, your lordship. If it can be taken up on Tuesday next, your lordship.
Do not know Tuesday.
In fact, your lordship, this has been extensively hard. But after that, your lordship, due to your lordship paucity of time, it could not reach, and then it was released from the part head, your lordship. Being Tuesday, your lordship.
We can try on 9th.
9th.
9th of June. Not this Tuesday, the next Tuesday. This Tuesday, we have already 6 cases fixed. So it will be burdened.
26. No? On 2nd, your lordship. Tuesday.
Tuesday.
That is what we are saying. On 2nd, we have got 6 cases already fixed. On 9th, we have got 5 cases fixed. This will be the
Let me take a chance, your lordship.
Okay, 2nd of June. At the request of the learned council for the parties. While Mr. S. Botakur has submitted that and the matter requires an urgent attention, it is submitted that the council representing the respondent is engaged in the special division bench. Place this matter on the 2nd of June, 2026.
Deeply obliged. Deeply obliged.
Yes, sir.
They please, your lordship. Your lordship, this petition was filed by 10 workers employees, your lordship, who were working against sanctioned post. And people junior to them have been regularized, they have been by mistake left out, your lordship.
And what does the respondent say on that?
Respondent, they also say that same thing, your lordship, because
by mistake left out.
The documents are there. I will carry you the document. All the documents are there.
Then why are they not?
And these people you have retired also recently.
No, why are they not regularizing that for one day and giving you the pension?
That's the problem.
Yes. Yes, Mr. Chaudhary. Admitted position. He is saying.
Lordship, here we have a file our affidavit.
It says it is admitted. You have admitted their case.
They were appointed against non-sanctioned post.
No, no, no.
Sanction.
It's a statement we have made, Lordship.
Documents are there showing sanction post, your lordship also. I will.
Paragraph 4,
Your lordship,
Lordship, 73.
I'll show that, your lordship, page 39, your lordship. Page 39 of the paperwork.
Yes, where do you say it is sanction post?
Page, your lordship, see, sanction. Page
Oh,
30.
subject at
Yes,
the
sir.
top.
Yes, sanction. And they've.
Lordship, only in the subject sanction of work charge post.
Huh.
Relating to a particular project, Lordship, for that purpose only. It's not a permanent in nature, Lordship.
Then how persons below them had been
It's regularized, yes, your lordship.
regularized?
Lordship, below them, maybe Lordship, they were appointed against sanction post. Lordship, that chart, I do not have how the process, but in the particular this case, the petitioners, we have made a specific statement, Lordship, paragraph 4, that they were appointed against on verification and but it was found that they were appointed against non-sanctioned post.
Your lordship, see para 4 of the affidavit, your lordship. That is a statement, the answer is begs to state as per records after by PWB, the proposal for regulation of 10 numbers of workers who were left out for regularization drive by the government has been moved by the final for concurrent. However, in the light of judgment, read appeal number so and so, Upendas and section. Upendas is not applicable. Upendas is against non-sanctioned post. This is sanctioned post, your lordship. And there are judgment to that effect, subsequent apex court judgment, which has totally overruled the Upendas case.
But if you come 2 lines below.
Yes, your lordship. They were not working. They were not.
Employees were working against a non-sanctioned.
No, we have been. I'll show from the records, your lordship. Records are here. I've annexed the documents here. They have not denied the documents here.
You have not filed any reply to this?
Yes, I filed a reply.
Where?
I filed a reply also. These are all sanctioned posts.
The reply to this.
Yes, your lordship.
Don't think is available.
We filed it. When did we filed it, your lordship? Reply.
Let's see. Okay.
Common rejoinder affidavit filed, your lordship. Just file. Just file, your lordship. Reply was filed, your lordship. Reply was filed, your lordship. We have filed.
No, we found it. But where do you say that the
Let's see.
You are saying 2 things. One would not be regularized due to absence of due to non-functioning on time.
One aspect is there, Lordship.
Then again you are saying that after re-examination you found that it was against non-sanctioned post. Oh, yes, sir. It will require some time. Huh?
Your lordship.
It will require us some time to find out how
Tuesday, your lordship. We will hear it on Tuesday. Next Tuesday, coming Tuesday, your lordship.
Not Tuesday. Tuesday we.
Then Thursday, your lordship. Thursday.
We can have it on the 9th at best.
Let it be partner, otherwise it will go down, your lordship.
Partner, then we are also tied down. If it is partner, then we are also part sitting. We can't tie the registry.
9th.
The paucity of time does not allow this matter to be taken up for disposal today. At the request of the learned counsel for the parties, this matter again on the 9th of June.
Tip. I've given the judgments also, your lordship. I've given the judgments also.
Is here.
Yeah, I've given the list of
We'll
judges.
see on the 9th if it is there, otherwise keep an extra copy.
I'll,
রাখিছে রাখি দিয়েছে Yes, sir.
Otherwise, may not be possible to do your lordship. Maybe on 4th we can try your lordship, some urgency on our part, lordship. Fourth.
Fourth overburden, no chance. 14 matters fixed till now.
Lordship is holding the
Our record is of 10.
lord.
14 difficult.
Maybe if we can.
9th.
9th, lord.
9th.
Paucity of time doesn't allow this matter to be taken up for disposal today. Learned counsel for the petitioners have expressed an urgency. Place this matter again on the 9th of June, 2026.
Lordship is keeping it far. No.
We've not even started. How
Lordship, lordship. Understand, lord. I was about to propose at 2 p.m. lordship. I was about to propose at 2 p.m. lordship the night.
Today.
Today, not on 9th.
What is the matter about?
Also, what is the lordship?
Don't open it. Don't open it. Just a.
My lord, this is regarding promotion. Now, in the first writ petition, my lord, they are the forester one, my lord, promoted to.
They are serving.
No, they are serving, my lord.
We're serving as foresters.
Then 9th of June. No hurry. Yes, what is this item? 370 কি হয় কিহত আছে হিয়াৰিঙত ইভেন্ট্ৰি হিয়াৰিং দিছে মই কি খবৰ None for the petitioner. None appears for the petitioner. The paucity of time would not allow the matter to be taken up today. List this matter again on 16th of June.
This is a disciplinary proceeding and it will take time because there is a case of no evidence. I will have to go through the evidence. It will take some time.
Evidence. Paucity of time, not today. We'll keep it on 18th. 18th of June.
No, other than 18, Malon, I think today I have fixed one matter in
23rd.
outside. Yes, Malon.
23rd of June.
Yes, Malon. Master.
Attendance বিলাক দিব দেই মই এতিয়া নাম কোৱা নাই নাম বিলাক লিখি দিব
This matter is of dismissal service, the bank service matter. Very perverse, by perverse order, perverse inquiry. And with malafide intention, he was targeted. And the person whom I have made the private respondent, he has been made the witness in the case, a single witness. And on the basis of his statement, I was shunted out from the service. So, my lord, it will take time. Can it be on 9th, my lord, 9th of.
A better scope would be on the 16th when we have got some space. 9th, 7 cases fixed.
Hearing.
On 16th, we have 4. So maybe on 16th, we can have your matter. Paucity of time, Mr. R.P. Sharma, learned senior counsel appeals. The petitioner assisted by Ms. Egan, learned counsel for the petition. Your name, sir?
A. Hussain.
Appears for the respondents. Paucity of time did not allow the matter to be taken up.
On behalf of M. Sharma. On behalf of M. Sharma.
Who is on behalf of?
On M. Sharma.
Okay,
and M. Sharma appears for? Whom? Respondent number what?
For Central Bank of India.
Central Bank of India.
Respondent number 2, Mohan Sabas. You are here without any weapon.
No, sir.
What is the weapon of an advocate?
Due to some personal difficulty, your lordship, he went.
He went, but where is the file?
And then he called me and he asked me to appear.
Where did you go? 16th of June, 2026.
Obligation.
Thank you.